of a case, my lord. This is regarding Panchayat election, my lord. Let be listed, my lord, on next Monday, my lord, 15th, my lord, for admission.
Panchayat election. You have it in July, in June. June 2nd or 2nd June.
2nd June. Let me, my lord, if possible, in the last week of May, my lord.
2nd June.
My lord.
Or any date later.
2nd June, my lord.
Okay.
May I please?
Yes.
With the consent of other side, Lordship, I beg to mention item number 19. May come up after 2 weeks, Lordship. Some person
19.
Lordship, hearing. I've taken the consent.
You have taken consent.
Yes.
19 on the request made by the council for the respondent, Mr. S.S. Roy, matter stands deferred to be listed after
2 weeks.
weeks. The submitted that consent of the council for the petitioner has also been obtained.
All right.
Therefore, listing matter for motion tomorrow, my lord.
When was it filed?
Yesterday, my lord.
Come Friday, Monday.
Yes,
What is the urgency?
The notice has been issued giving the petitioner 7 days time to file a reply. But this notice is issued in contravention of this court's order, your lordship.
It's all right. We'll come on Friday. No? Why tomorrow? Friday.
Last year.
Friday. You filed it yesterday. Come on Friday.
Notice issued only 3 days back, your lord. Saturday and Sunday was last day.
So let it be on Friday.
May it please your lordship. Lordship, I beg to mention item number 8, lordship. In this case, we will file addition and affidavit, lordship. Matter may come up after 2 weeks.
You want to file?
Lordship.
Item 8 on the request of the council for the petitioner stands deferred to be listed after 4 weeks.
Lordship, I beg to mention for listing of 2 matters for hearing. The matter pertains to promotion from grade 4 to grade 3. So the matter will be listed on inconvenient.
For hearing.
Yes, sir.
Can't be listed for hearing. You bring it for orders. 1st of June, let it be for orders. We'll fix a date for hearing.
I beg to mention for listing, madam, the last listed on 24/9/2025.
For admission.
Yes, ma'am. Need it.
2nd June.
Wait, please, lordship. Lordship, I beg to mention one orders matter for listing. Lordship, if possible by tomorrow.
By tomorrow, not possible. Let it be on 18th.
May please your lordship. I beg to mention for listing of writ petition for withdrawal, my lord. Tomorrow. My lord, one pending matter, my lord, regarding selection and appointment of Gaburas. So, lordship on next date, my lord. So,
For admission.
for admission, my lord.
We'll have it on 2nd June.
Otherwise,
May I please your lordship. Lordship, I beg to mention item number 16. Lordship, kindly pass over the matter for today.
Item 16 on the request made by the council for the petitioner
Yes, lordship.
stands passed over for the week. Listed after
In
1 week.
this matter, I am for the respondent, Lordship, 2 to 5, Lordship. Lordship,
Mr.
we also need to file an affidavit. Lordship, may kindly fix it after
You're
2 weeks.
Mr.
W. Rahman on behalf of S. Datta, Senior Counsel.
Mr. W. Rahman appears on behalf of Mr. S. Datta,
Senior Counsel.
Senior Counsel, submits that for Oil India.
Yes.
Submits that an affidavit is required to be filed. He prays for 3 weeks' time. Therefore, the matter be listed after 3 weeks. However, 1 week. Yes.
Please your lordship. Mention for listing on WPC for orders
Orders 1st of June.
Friday,
Friday not possible.
Monday,
Already 18th.
of less.
Yes, Mr. Bora.
my name is serial number 28 in supplementary list.
We'll take it up in the second half.
By the motion. The order by which the regulation order was recalled.
that, Nicholas, even if that was issue, that was never communicated to the petitioners. So, that will have no bearing to the case. I think, there is no order. Just had there been any order, that should have been communicated to the petitioners also.
Yes,
Happy, Your Lordship. Your Lordship, the learned counsel, Mr. P. Naik is not available today, Your Lordship, due to personal difficulty.
yeah, we are not accommodating like this. We've given you time on the last date. Can't go on like that. These dates are fixed in the presence of counsel. So have you circulated an adjournment slip? Was it circulated?
Consent was taken, Your Lordship.
Is it?
They have informed me that he'll be busy in the swearing.
Oh.
They informed me that matter, but I did not give it consent.
He'll be busy in swearing in.
Fine.
Is he also being sworn in? Kind of a request I am making. The proper procedure is to circulate the adjournment slip. You circulate it. There's a procedure, you should have done it.
Now it's to be
All right, 14th. The request made on behalf of Mr. P. Naik, additional AG. As it is submitted that the counsel is not available in court.
Lordship, kindly see the last order dated 12/3/2026.
Respondents have not filed affidavit.
They have not filed affidavit, they are not, they are supposed to take instructions.
We have already
complied the
implemented,
order.
Lordship. 2 weeks may be granted.
Hmm?
2 weeks may be granted.
Find the direction,
What is the direction?
page 62. They have to pay pending salaries. The petitioner, 62. Those employee petitioners, they were handed over to local bodies, that is Silchar Municipal Board. They are, Lordship is directed to pay the, release the pending salaries. The salaries pending, the arrear salaries from for the period from month of June 2021 to January 2022. One part, and another part is March 2025, April 2025 to March 2026. Further directed to take financial aid from the state government as per constitution provision, and the government was also directed to consider the grant.
Mr. H. Sharma, H.K. Sharma for the petitioner, MS S. Muzahari, appears for
Respondent number 6.
respondent 6, who prays for further 2 weeks' time.
Number
Similar prayer is made on behalf of respondent 2. Stop earlier by order dated 2004, 2 weeks' time was granted to the respondents to file. Stop. Today also the same prayer is renewed. Stop. Purely for the ends of justice, matter is deferred to be listed after 3 weeks, by which date, if the respondents do not propose to file their counter affidavits, the court may proceed for hearing on the basis of the pleadings available on record. List after 3 weeks.
Date may be
11th June.
early of that.
This case, my lord, on last,
The
order was passed directing the government advocate
to take instruction with respect to the my lord letter, one letter issued by the my lord, it is in annexer 80, page 83 of the running page. my lord.
Here, some more time is required, was it?
What more time? There are two judgments, three judgments.
Yes, Lordship.
Then what instructions are necessary?
And on that day,
Yes,
your lordship was directed for personal appearance. So then they have took time for 1 day. Now 3 weeks time has over.
Next time.
Yes, yes, Mr. Goswami.
Lordship, some more time is.
Why? For what purpose?
Yes, Lordship, Lordship, so far, Lordship, in this case, Lordship, the file is not raised.
Huh?
That, Lordship, as per my instruction, Lordship,
You call the officer concerned. Who's the officer?
Lordship, fix the matter.
No, you call the officer. We'll fix it, but we want his presence here. Who's the
Lordship,
officer who's
I
refusing to
will
give
bring,
instruction?
I will bring, Lordship,
What is this?
I-
Time after time, date after date, we are giving you accommodation.
I will,
And in fact, this order, my lord, is sitting over the judgment passed by this man.
Right, there are two,
This
three
letter-
judgments here.
Sitting
Yes,
over
Lordship,
the
that's-
judgment.
Three judgments.
Two
How many
judgments.
judgments? Two judgments.
Two judgments and another, yes, two judgments.
Two judgments are passed.
And in contravention of the order of the judgment of this honorable court, this letter has been issued by one joint secretary. Even after this letter also, the secretary and commissioner also issued clarification to that effect. That is also I have annexed. my lord.
Monday, Lordship, I will bring.
On the last date, your colleague was present.
Lordship.
Today, you are there.
No, Lordship.
Monday, we don't know who will be present.
No, I will be, Lordship, because I discussed with my colleague, Lordship, about the position, Lordship, and after that, Lordship, I appeared with your Lordship. I will appear in the morning.
Heard Mr. S.K. Ghosh comes. and
Lord,
goes.
may I pray, my lord? One letter I want
Let them
to-
obtain the instructions, whatever
No.
they want.
Let them take instruction on this letter.
Which letter?
Annexer 4, page 29.
It is the office memorandum. Annexer 4.
What instructions?
My lord, here they have clarified that the revised basic pension in no case shall be deceased. So in this case, my lord, it is applicable to pensioner and family pensioner also. And the letter which,
The Mr. J.K. Goswami, the National Senior Government Advocate, renews his prayer for further time. He, however, assures that he will have the required instructions on the next day. Submits that the matter be listed on 18th of May. Mr. Goswami will obtain instructions with regard to the OM dated 30th of July 2018. In view of the claims of the petitioner, that this clarification issued by the OM is equally applicable to family
family
pension
pension.
based on 18th.
Lordship, here I am appearing on behalf of the municipal board, Lordship.
Hmm.
Respond number 3 and 4, Lordship. Lordship, on last occasion, I obtained time, Lordship, to obtain instruction. And yesterday I have been instructed that another 50,000 has been given to the petitioner, Lordship.
But you are not giving him.
Lordship,
Because
we
he
have
is-
brought everything on record, Lordship, through our affidavit, Lordship. Thereafter, the petitioner, we wanted to, that means give the money. But he was so adamant that he wanted to obtain everything in one go, Lordship. Because, Lordship, the municipalities are not in that
That is not-
financially, Lordship.
That is not his concern, really. He is entitled to his benefits.
Yes,
You have
Lordship,
to
but
give him-
Even
But
not
we-
a single penny from my gratuity has been paid. And
You
it
should
carries
pay,
insurance.
but you are making
Lordship-
people run around as if you are giving them something.
Lordship, if your lordship kindly
Lordship.
peruse our affidavit, we have stated everything, lordship.
No,
In the
not,
mediation,
not having money is not a ground. Then you'll have to go for winding up of the board that you have no money. go
Municipal
for-
boards are lordship like this only. They, when they are unable
Lordship,
to,
since 2016, I'm suffering. So Lordship matter may
You
be
should
hard
go and
file.
file a suit. Why did you come before the court? Why
Lordship,
did you
because
not
they-
file a proper suit?
Lordship, these are undisputed amount, the amount they have admitted
You
in the
can
affidavit
argue,
that I have.
Mr. Counsel, you can keep on arguing. But we are not here to give you an advice. You are coming here asking for a writ.
Yes,
But this is a matter of evidence. This is a matter where you require records. The proper forum ought to have been a proper civil suit.
no, Lordship, they have admitted in the
Where
affidavit.
you'll have if you get a decreal amount, then you get at least executed.
Lordship, here the amount which I'm claiming, they have admitted that exactly the same amount is due to me. They are saying that only the
Learned
stamp
counsel
taken.
for the petitioners.
This may be finally hard, Lordship, a date may be.
We are hearing you.
Yes, sir.
We'll pass an order that the amount should be paid. The question is, how do you recover it?
Lordship,
How will you recover it?
Lordship, they will have to pay because
How will you recover it?
if a direction is issued, it is their duty because they have the fund. It is not that most of the funds were sanctioned. And gratuity, the payment of the gratuity says,
You are asking the High Court to become an execution court.
no.
Then we are passing an order. How do you intend to recover it? Give us an example. Give us your
Because
views.
in many cases, the High Court has given to release the pensionary
Of
benefits.
course,
in
we'll
civil
do it. But the
cases.
question is, then you'll come back with a contempt petition, which will be pending for the next 5 years.
Lordship, if I go to a civil suit at this stage,
We don't know. We are not advising you. We are only asking you that in matters like this, the proper forum should have been a civil court.
Lordship,
But you choose to come before the High Court and you are demanding the amount should be released. Yes, we agree. We'll pass orders. But High Court is not the executing court.
Lordship has sent the matter earlier to the mediation. And what they have proposed is that they will pay 25,000 per month.
What proposals have you sent to the department for release of these payments?
Lordship, that exactly I don't have, lordship.
And
Nothing
is
has been
the executive officer, the chairman, are they getting their salaries?
Yes,
They, because lordship, as per that means municipal act, lordship, they have to raise their own fund, lordship. So whatever they raise, lordship, these are spent on their salaries of and maintenance of the
So
staff and all these things, lordship.
those salaries of
And
the hearing
lordship.
officers should be deducted to clear off the debts. Why are they receiving salaries? If there is no money.
Then lordship, if your lordship may kindly peruse the affidavit filed by the municipal board, they
Yes.
stated that there was a proposal to the petitioner to accept lordship monthly 50,000 or something like this, lordship. So by this time, everything would have been lordship paid, but he was not. He was adamant. He was not agreeing.
Nothing has been stated.
Yes,
and no
lordship, in
document
the
has been
affidavit
annexed.
it is there, lordship. He may not have.
Now, I have stated in the affidavit.
Filed by respondent 3.
Yes, lordship.
Which paragraph?
Lordship, they have made this statement in para 8, page 39, running page number 39. With regard to the statements made in paragraph 10 of the writ petition, the deponent begs to state that the Gauhati Municipal Board has offered the petitioner number.
You are reading
times.
from which paragraph?
Page 39.
39 is something else here.
Lordship.
You are reading from the affidavit filed by
affidavit in opposition filed by the respondent number 7.
7.
Yes, Lordship.
Yes, respondent 7. Who's respondent 7?
He
The
is the
chairman.
chairman of the municipal board.
So there is another affidavit by respondent 3.
Okay, that has. The Gauhati town committee is now no more there.
Yes.
It says that they have The available deponent begs to state that the available municipal board has offered the petitioner number of times to accept the retirement benefits which the board intend to pay in installment basis, as the financial condition of the board is not self-sufficient to pay the entire dues at a time. But the petitioner all along refused to accept the board. Lordship, I denied this. Yes, they have proposed me during mediation to take 25,000 per month. That I have refused because after 10 years of my retirement, they are proposing me to pay 25,000.
How can it be lordship? Because the affidavit was filed on 27/7/2023 lordship. How they can say that this was after in the mediation we have stated? In paragraph
No,
8 lordship,
this
it is
I have
stated
denied.
lordship.
What
have
is,
denied
what is the amount due?
Lordship, total amount due was 10,23,200.
What is the amount released?
Amount out of this amount only 1 lakh has been released.
Hmm?
Out of this amount only 1 lakh has been released.
Page 54, paragraph 16, just before para 8.
Oh, that is the amount that has been released. That is CPF amount has been released.
5,55,000
If
altogether.
that is included, then my dues was 14 lakhs something. This 5 lakhs 55,000 includes, actually this was 4 lakhs 33,431. With interest, it comes to 5 lakhs 50,000 that has been paid. That was CPF amount that has been released.
CPF
but
also
there is
that
a-
time we proposed lordship, but he did not take the lordship.
CPF amount was paid. During mediation, he took the CPF amount. That I have stated.
During mediation he took, but others earlier he did not take.
Total amount due to me was 14 lakhs 56,631. Out of that, the CPF amount was paid. And then 1 lakh was paid.
What is the balance amount to be paid now?
Lordship, the total amount to be paid now is 9 lakhs.
You bring it on record by way of a short additional affidavit.
I have filed that.
Where is that?
Lordship, there is an affidavit. It starts from page 40, running page number 47. This is an affidavit in reply that I have filed. There I have cleared.
47. Yes.
Page 51 is the relevant portion. Towards CPF contribution, that unpaid amount for 39 months.
Which paragraph?
Lordship, para 10, page 51. The deponent oblique petitioner states that he is now entitled to the following amount towards his retirement benefits under different heads. Towards CPF amount, CPF contribution, both employee and employer's contribution for 39 months, that is from the month of 31/5/2000 to 21/9/2003. That was unpaid amount. Leave salary, unpaid leave salary of 1,37,380 because 1 lakh has been paid. Gratuity amount 3,91,677. And arrear salary, difference of the pre-revised and revised salary, that is 3,94,143.
What do you say with regard to?
Lordship, as per my instruction, the leave salary pending is 87,380 and amount due towards gratuity is 3,91,677. This much is due, Lordship.
Arrear salary is also.
CPF has been released.
Yes, it has been released.
Lordship, they have released the CPF that they have deposited before the they deducted from me the CPF for the month of 31/5/2000 and to 1/9/2003, and that has not been with the employer's contribution that has not deposited before the concerned authority. So that was not released to me. And secondly, the arrear salary, it was released by the government, and they have not paid. And they prepared the bill. That bill I have annexed with my writ petition that I got under RTI.
Who's the executive officer there? Executive, what do you say? Executive officer.
Is chief executive.
The when there are chairman, Lordship, chief executive officer has little limited role to play, Lordship. The chairman, because the board is run by the chairman,
No,
Lordship.
if you admit that yes, these amounts are required to be paid, there is no dispute, then you have to make arrangements.
Lordship, that's what exactly, because
This
in our
admission-
affidavit, Lordship, page 39, we already have stated that there are certain the affidavit filed by the respondent number 7, Lordship. in July 2023 in page 39, paragraph 8, Lordship. Lordship, in the middle, if I may say, Lordship. That would trigger the statement paragraph 10, Lordship. Gauhati Municipal Board has offered the petitioner a number of times to accept the retirement benefits which the board intends to pay in installment basis, as the financial condition of the board is not self-sufficient to pay the entire dues at a time, but the petitioner all along refused to accept the offer made by the board. The board could not even manage to pay the salary wages to both the payment and contractual employees for more than a year, and the present liability for making payment of arrear monthly salary to the employees has become more than 1 crore. The financial paucity of the municipal board is mainly due to poor collection of taxes and funds. As such, the board is unable to meet up the claims of the petitioner, and this is only reason of non-payment of entire retirement dues to him. It is pertinent to mention here that had the petitioner cooperated by accepting the part payment, the entire retirement dues would have been paid to him by this time. But the fault is with the petitioner, who always refused to accept the payment in installment as offered by the board. It is further to be stated by the deponent that 10,23,200 is due to be paid to the petitioner in respect of leave pay, salary, gratuity, and arrear pay. The petitioner can withdraw the CPF amount of rupees 4,33,431 at any time he wants to, but the remaining payment of rupees 10,23,000 has to be accepted in installment, as the office of the deponent is unable to meet up the claims of the petitioner, pay the entire amount at a time.
What is the installment that you propose to give?
Lordship, now I have come to that on 24/4/26, 50,000 has been paid. If we can, Lordship, I can tax the 50,000 per month if this
No,
can.
not 50,000. What is this 50,000?
Lordship,
You pay 1 lakh per month and finish off the debt, whatever is there.
Lordship, this gratuity amount.
Lordship,
there
then,
is interest also.
Lordship, kindly fix it on next week any day. I shall obtain instruction and appraise your Lordship.
Yes.
Lordship, regarding this 10,23,000, now they are saying that amount due is leave salary and gratuity. Towards leave salary, they are saying that 1,37,380 rupees and gratuity 3,91,677. But they have admitted in their affidavit that total amount due was 10,23,200, and out of which the 1 lakh has been paid. So total amount due is now, this includes the leave salary, gratuity, and arrear salary. And they have not stated anything about the undeposited CPF amount and the arrear salary. They are saying that it is not due to me, but they have in their affidavit they have admitted that this is also due to me.
Which part of the affidavit?
Lordship, in page 39, they have stated of the affidavit in opposition filed by the respondent number 7. The deponent has admitted that the remaining amount of 10,23,200, out of which they have paid me 1 lakh towards leave salary. Now, I have stated in my para 51 of my affidavit in opposition, affidavit in reply, that leave salary, unpaid leave salary of 1,37,380 rupees, plus gratuity 3,91,677, and then the arrear salary of 3,94,143. If these are added together, it comes to 9,23,200. That is, out of 10 lakhs, 1 lakh has been paid. So it is, there is no dispute regarding the amount due to me, except the amount towards CPF contribution, undeposited CPF contribution.
If this be so, Lordship, then I also have to observe what actually is remaining, Lordship, in balance.
Of course, you will have to
Yes,
do that.
Lordship. And I shall file a small affidavit bringing the calculation on record, Lordship.
Lordship, this may be the last one, because
What
it will
last
be
chance?
time
They are
taking
keeping
Lordship.
on raising one after another,
No, I have
which
not
are not
raised,
at all, Lordship.
These were there in my
Nothing you are
petition
mentioned
also.
there, Lordship.
These were there in my petition also. In para 6, I have stated.
You tell us when you can get the instruction.
Lordship, 2 weeks, Lordship. I shall bring this on record, Lordship, the instruction along with the entire calculation, Lordship. Whatever is due and what they can pay, Lordship, in installment.
The claim of the petitioner towards his financial benefits for the service rendered under the Gauhati Municipal Board. Having not been released by the municipal board, the writ petition being filed. So the readings are exchanged. While the petitioner's claims for the area dues, all area dues, inclusive of leave salary, gratuity, CPF, etc., are urged before this court, are being urged before this court, seeking a direction to the municipal board for release of the same. The municipal board, the chairman of the municipal board, by its affidavit filed on 28th of July, has made a categorical averment that an amount of rupees 10,23,200 is due to be paid to the petitioner. So thereafter, the matter was referred to mediation, where at the mediation, the petitioner accepted the CPF amount, amounting to
Amounted to
5,55,000. I think.
5,55,000. So the writ petitioner, however, submits that it is only the municipal board's share that has been paid. However, the contribution made by the, what have you stated?
Lordship, I have stated that that amount is that has been paid. There is no dispute, and another amount is unpaid. That is the CPF amount from the month of that I have stated in my affidavit.
That 5,55,000 does
Oh.
not cover the entire amount.
No, Lordship, because they failed to deposit the CPF amount that was deducted from me with the employer share from the month of 31/5/2000 to 1/9/2003.
That is what we are saying.
Lordship, that was not paid.
Writ petitioner, however, disputes that the amount released to him includes the share deducted from the employee towards CPF. For which period?
Lordship, 31/5/2000 to 1/9/2003.
31/5/2000
2000
to
to
1/9/2003. So, state contention, however, is disputed by the learned state council representing the municipal. And under such circumstances, the council also submits that they are agreeable to, in view of the extreme financial, acute financial shortage faced by the municipal board, and there being no financial benefit received from the government. At present, the municipal board is agreeable to pay the dues payable to the petitioner at a monthly installment of rupees 50,000. Considering that there are some disputes with regard to the amounts payable to the petitioner, payable by the municipal board to the petitioner, let the respondent complete their instructions and give a complete particular of the amounts required to be paid to the petitioner. So it is also made clear that, in the opinion of the court, the amounts payable to the petitioner should be released as expeditiously as possible. And upon such instructions as may be furnished before the court, this court will decide the appropriate manner in which the amount is required to be disposed of, released to the petitioner. Based again on
Lordship, can it be on second, Lordship?
4th June.
Lordship.
Much.
Developed.
Lordship, kindly pass over the matter for the timing.
In the timing. We don't know, 2 PM other matters are fixed. You come back at 2 PM. we'll try. Yes. Yes,
The senior is on live, your lordship, can you pass over the matter for?
we can't pass over all matters.
Well,
You already passed over.
Very
today.
thick some other day, well, here, they have heard, well, that some NRL has filed an affidavit. I have received it.
Who has filed?
NRL.
NRL is a party here.
Party. Who is the party?
OIC,
Why say? We have not,
Oriental Insurance, but they,
who is the party?
Oriental Insurance was impleaded as party, respondent number 7, service was complete.
No, they
You're
command-
appearing for which one?
Normally got commandant, normally got mother party.
Huh?
Commandant CS, this one or 3.
Respondent 5. Ah,
So they have filed it.
Saiwala you're appearing for?
I am for 5 and 6, madam.
Who are 5 and 6?
The father and mother.
Father and mother. So it's a claim for the benefits
Yes.
of the deceased soul.
My lord. And they have not obtained satisfaction certificate, my lord.
They are the petitioners. They are the what? The wife, widow,
You say second wife.
second wife.
No, your lordship,
Huh?
first one,
First
there is no second one,
wife.
there is no second one.
Well,
Yes.
let it come next week, my lord. I shall collect a copy of the affidavit filed by the.
Can you pass over the matter for time?
Let it be next week. Give whatever pleadings are there, you give it to Mr. Saiwala. Placed on 21st. As prayed for by Mr. Saiwala. And so and so forth. Mr. R.K. Dev Chaudhary for 123 MS. N. Chaudhary for J. Burma.
Matter also wrote.
Huh?
For some time.
Have it on some other day. Let it be listed. What is this about?
Terminal.
Huh?
Dismissal.
Dismissal matter. Pleadings are changed.
Complete.
Issue rule. This is the matter for hearing in the month of July.
What is the development note?
Huh?
We have also filed a criminal petition note for quashing the note. And cases of the finance, lordship will not issue rules with an admission.
You don't tell us what we should
Lordship,
do.
lordship.
We will issue rule,
Lordship,
the matter should come up for hearing.
Lordship.
That's all.
I'm for the petitioner. And my application under section 11 for appointment of the arbitrator.
Who for the other side? Railways. What is their objection?
Or they are taking this objection that the on the ground we have filed this application including the point of disputes which are not arbitrable in nature. Only it is well settled that your lordship has also decided that point of arbitrability can only be decided by the learned arbitrator. In a referral court, my lord, whether existence of arbitration clause is there or not, that needs to be looked in. That is the point before your lordship.
Where is the section 21 notice?
Yes, my lord. If your lordship kindly comes, allow me. Page 355 on 15th of February 2024. Annexure 7. There are disputes regarding security deposit, evocation, releasing of performance bank guarantee, evocation of liquidated damages, and others. That is the problem. I understand, but yeah,
Yes. What has happened?
Your lordship, my senior is out of station.
Who is your senior?
H. Gupta.
Why have you not informed the other side? There's a system of circulation. Why did you not do it?
But I'm coming from Kolkata, my lord. That is the problem.
What is the problem? Kolkata is just round the corner.
I understand, but my lord, on the last occasion, we took time on
You're
my
entitled
instance.
to appear through virtual mode if you want to.
Yes, my lord. That will be better for me, my lord, if your lordship so grants me that.
It is for you to apply. When is it likely to be back? See, there is a procedure for seeking consent of the council. Why did you not do it if he is indisposed?
Apologies.
If the council is indisposed,
I should not make any objection since it is.
when is it likely to be back?
After 15.
And thereafter there will be summer vacation.
When are your summer vacations starting?
Around 23rd month.
We'll have it on 19th.
19th. Can it be any Monday, my lord, subject to your convenience?
Monday may not be able to give you a hearing. Their hearing days are Tuesdays and Thursdays. But we can put it on Monday.
Subject to your convenience, my lord.
19th would be convenient, 19th or 21st, whichever date you want.
My 19th would be convenient for me.
19th.
9th.
You're Mr.
Shayok Gangu.
S. Ganguly.
Is
Learned counsel for the petitioner, MS
P.R. Chaudhary.
P.H. Chaudhary appears on behalf of Mr. H. Gupta, Learned CBC, submitted by MS Chaudhary that Mr. Gupta is indisposed and he will be back in station and is out of station for treatment. So as agreed to by both parties, let the matter be listed again on 19th of May.
Can it be 21st? My learned friend has certain difficulty. 21st, if your lordship.
We have some other matters fixed on 21st, so we can't give you a guarantee that will be taken up. We can fix it. At least on
19th. My 19th.
19th. Okay.
May I take your leave?
Yes.
My lord, the other day my landed page raised certain objections. Meeting all the objections, we have filed additional affidavit that is filed yesterday, but we have got extra copy of our lordship desire.
If you filed it, it must be on record. Why have you filed it yesterday?
They did not get the leave, my lord. That is the problem.
Have you been served, Mr.?
Yes.
We will start, but I check up that it recorded from here.
Let it come. Mr. Mahmood, learned counsel, M.V. Mahmood, learned counsel for the petitioner, submits that an additional affidavit has been filed yesterday. So copies have been served on the counsel for the respondents. There are the said affidavit stated to have been filed, however, is not connected to the case record. It might have been listed on
Short.
28th of May. Registry will trace out the affidavit stated to be filed and by
Interim
the
order.
petitioner
Okay.
and connected to the case record.
Interim order. And therefore-
Interim order, if any, will continue till the next date of mistake. This is the deputation matter.
Yes.
But it speaks on 20th.
228. Yes.
It's the issue order dated 14/8/2025. Whatever in this case, my lord, petitioner was initially appointed as Gauhati of the village in Dismissal, my lord, on 14/7/2024, page 11. Subsequently, on 16/7/2024, his appointment was cancelled. Now, my lord, challenging that order, I have approached this honorable court again by filing a petition, my lord. The page 13 onwards is the petition. And the honorable court has set aside that order, my lord, by his my service was cancelled, my page 16, my 16 is the operative part. Paragraph 60.
Thereafter, what happened?
No, my lord, no, by this order, my lord, the appeal order was set aside, my lord. My lord, kindly turn to page number 1717.
Yes.
My lord, and it was issued, my lord, by the additional secretary, will be the meeting, my lord. My lord, at the bottom, my lord, copy to my lord. In spite of setting aside the order, the private respondent was allowed to hold the post of the Gauhati. And now, my lord, subsequently, my lord, the appeal order was passed, my lord. That nothing was done, my lord. Purpose of this honorable court.
No further hearing was,
So, hearing just paperwork, man.
no hearing.
So, the stand is that, my lord, in the appeal order, lordship, page 25. Pursuant of the honorable court order dated 23rd May 2025, the undersigned has deputed the Mujadar of Wajo village and two assistant revenue officer and lot mandal sir by letter on 6/6/2025 for hearing. Accordingly, a meeting was convened on.
You did not file any contempt or anything like that?
And my lord, a contempt was pending, my lord, for non-compliance of this order of the honorable court.
What happened to that contempt?
That notice was issued.
Huh?
Notice was issued. Now, my lord,
Now, why have you filed this petition again?
my lord, because of this 14/8/2025,
14/8,
for page 25, my lord.
page 25.
This is the appeal order. May read, my
Yes.
in pursuance of the honorable court order dated 23rd May 2025, the undersigned has deputed Mojadar Sir Sanso by letter dated Sanso.
6/6/2025 for hearing. Accordingly, a meeting was convened on 26/2025 at 11 a.m. In Southern Village, and every effort has been made to hide from both the sides at length. However, both parties were unwilling to negotiate with each other. And in view of the joint meeting, the report submitted by the Mojadar of Wajo Moja, 2 assistant revenue officials and 1 so the North Kachar Autonomous Hills Autonomous Council has decided that 3 sons of private respondent shall continue Gauhati of until further order. My lord, what was the order of this honorable court, my lord?
Order was to give you an opportunity to be heard.
My lord,
That was done.
nothing was done. My lord.
Why? This order says that.
Now, my lord,
Records, my
Lord, if my lord, if this order was, his appointment was set aside, private respondent appointment was also set aside by the impugn order, my lord. And my lord, I have shown your lordship.
You read the order of the High Court,
Lordship. Under the,
penultimate paragraph.
under the circumstances, there being a violation of principle of natural justice, impugn order dated is found to be unsustainable and accordingly set aside. However, setting aside of the impugn order dated would not mean a automatic reinstatement of petitioner.
That's it.
Now, my lord, regarding appointment of the private respondent, my lord, his appointment was also
Somebody will have to be there.
No, my lord.
You file the petition, court pass this order in your writ petition.
Now, my lord, in the meeting, my lord, no decision was taken, my lord. This is only because, my lord, to protect the private respondent, my lord. This order was in earlier round of litigation, my lord. I could
So pleadings are exchanged.
exchange, my lord.
What records are available?
Private respondent.
Take it up for hearing. What is the term of this? What is the tenure?
No, my lord, we will continue, my
Continue.
lord. Continue.
Heard counsel for parties, pleadings are exchanged, issue rule.
No, my
Call for the records, place this matter in part 2 hearing list for the month of July.
Now, my lord, lordship, only one thing, my lord. Can it be disposed at the admission stage?
No.
Or, my lord, in spite of this honorable court stay order, my lord, impugn order has been stayed, my lord.
Where is the stay order?
My lord, in the motion stage, my lord, stay was granted by this honorable court, my lord.
What is the stay order?
10/9/2025, stayed till returnable date.
Huh?
10/9/2025.
Nobody has filed a vacating petition.
No, my
Who is holding the office now?
The private respondent.
How? In view of the stay order?
because of that, my lord, and I could show the hearing, the notice for hearing, my lord, which also shows that the private respondent was holding the post
The
of-
order was passed on 14/8/25.
Hmm.
So from that day only he is continuing.
Hmm?
From that day itself, the private respondent is continuing.
And 10/9.
Then it is necessary for the department to apprise that the interim order needs to be recalled. Nothing is said.
Not aware, but I'll just go through.
On 10/9/25, stay was granted.
What is this? Not aware. It was passed in the presence of the
Standing of
Dimasa Council.
10/9. On 10/9/25, stay order was granted by this honorable court. And impugn order is of title 14/8/2025, man.
We'll let it come
In-
on Thursday, minute, I'll just press the court number.
When, my lord,
I would like to cut it. Heard the counsel for the petition. Petitioner is aggrieved that by the impugned order dated 14/8/2025, whereby on the basis of the joint report submitted by the Mozadar of Wajao Moza, 2 assistant revenue officers and 1 lot patwari of the office, the NC Hills Autonomous Council has decided that the private respondent, Sri Joymanto Vijay, will continue as a Gauhati of Proceeding village until further orders. Stop. This order was passed in deference to the directions contained in the order dated 23/5/2025 passed in WPC 5590 of 2024. Stop. By the said writ petition, the following directions was issued, para 6 extract, page 16. It is pursuant to this direction that the impugned order dated so and so was passed. So the writ petitioner has approached this court, and by order dated 10/9/2025, the impugned order was suspended till the returnable date by orders of this court. So the said impugned order, said interim order was extended from time to time and is still in force. Where today, when the matter was heard at some length, counsel for the petitioner submits that notwithstanding the interim order, the private respondent has been
Take instruction.
Allowed to continue as a Gauhati. So there are on perusal of the order dated 10/9/2025, it is seen that this order was passed. This order, including the interim direction, was passed in the presence of the learned standing counsel and Senior Autonomous Council. So it is therefore not understood by the court as to how the private respondent could be allowed to continue as the Gauhati or the so-and-so village in the face of a clear interim order suspending the order dated 14/8/2025 impugned in the present writ petition, and by which order the private respondent was allowed to continue as a Gauhati. Stop. There is no application filed by any of the respondents seeking vacation or modification of the order dated 10/9/25. Stop. There are prima facie, it appears to the court, that the interim direction of the court. Prima facie, it appears to the court that the private respondent has been allowed to continue as a Gauhati in complete violation of the interim order dated so and so, passed by this court, and which order is still subsisting. The pleadings in the proceedings have, in the meanwhile, been exchanged, and there is no averment made that the interim order dated so and so, passed by the court, was not communicated to the Mahasa Council, the Mahasa Autonomous Council. Stop. There is no representation also from the private respondent, in spite of notices being served. Under such circumstances, we permit the learned standing counsel, the Mahasa, MS P. Chakravarti, to obtain her instructions as to how the private respondent was allowed to continue as the Gauhati by virtue of the impugned order dated 14/8/2025, when the said order was suspended by orders of the court dated 10/9/2025. Relist this matter again on when?
Next Tuesday.
19th. 19th.
Right.
Lordship, could it be taken up after some time? Pass over matter.
Lordship, there's some difficulty, Lordship. Here, otherwise we have filed the
We have
affidavit.
also filed the rejoinder affidavit.
Yes, they have filed the rejoinder affidavit, Lordship, today. Otherwise, the main dispute is regarding the gratuity amount, Lordship. We have given our calculation.
Lordship, the dispute here is that the DA has not been calculated by the finance department, which has been
No, it
calculated
has
by
been calculated as per rules, Lordship, that we have stated in our additional
Lordship, in
affidavit.
our rejoinder, we have annexed the amount which has been given to the similarly situated employees, Lordship. There, the DA has been calculated, Lordship, but in our case, Lordship, the new figure
No,
which has been
yes.
given by the finance, there is no mention regarding the DA part, Lordship.
No, they're not entitled to it as per rules, Lordship.
Lordship,
That we
but-
have stated in our additional affidavit.
But Lordship, the calculation done by the department, Lordship, it clearly shows that the DA is entitled, Lordship.
No, Lordship, that is a wrong calculation because of which the treasury officer had created the objection, raised the objection in the first place. Now, we have given our calculation, they are disputing that amount. We are saying the amount which is amounting to around 4 lakhs, Lordship, that he is entitled to and that we are willing to pay subject to the
Lordship,
DDO.
there is no clear definition where I have.
We have stated that, Lordship.
No, there is no rule mentioned, Lordship.
The additional
In the
affidavit,
financial rule, it simply says that.
So what's the rule, what you were claiming?
Lordship, 153 of Assam Service Pension Rule.
153.
153, Lordship. The second part, Lordship, pension and gratuities, Lordship. May I read, Lordship? Lordship, may I read, Lordship? Payment and gratuities. Members of work charge establishment are not ordinarily entitled to any pension or gratuities. Won't do extraordinary pension.
You're reading from 153,
Lordship, 153, Lordship. The extract,
1532.
two, Lordship, yes.
the extract part of 329 of the financial rules, Lordship.
Read.
Members of the work charge establishment are not and ordinarily entitled to any pension or gratuities. Won't or extraordinary pension and gratuities are, however, in certain cases admissible in accordance with the pension rules. All members of work charge establishment who are not entitled to any pension on their retirement will be granted gratuities in the following scale. Lordship, here I have completed.
What was your service?
Lordship, we are the petitioner again is a work charge employee. Lordship, who is
What says employee? In which department?
in PWD department.
PWD.
So the
Then?
service was not regularized, and so we are
Regularized.
claiming the gratuity, Lordship.
Noted.
According to Lordship, initially we had not even provided this,
So
Lordship.
your claim in the writ petition is only with regard to gratuity.
It was also the GPF, Lordship. GPF has been already been
Released.
So released, Lordship.
Right.
Now we are on this gratuity, Lordship.
Now, this may be granted is a decision to be taken by the department,
Yes, Lordship. Department has accorded the sanction, Lordship.
according to sanction.
Lordship.
Now, who has objected?
Lordship, the
Finance-
treasury the
Why?
treasury officer.
Why?
Lordship, because as per rule, Lordship, which my learned friend was reading, we have stated that in our additional affidavit. We have shown the calculation. Lordship will have page 60 of our additional affidavit, Lordship.
60.
Yes, Lordship.
It is the fresh calculation, Lordship. In the first affidavit, they have not mentioned anything about the.
No, Lordship, that we have,
On the
it is
direction of
stated
this
in our
honorable
first
court,
affidavit.
Lordship, now they have filed under additional affidavit and now they have come to a new figure, Lordship.
No, Lordship.
Yes, there is a.
Okay, let me submit also. We have given the right calculation, Lordship, page 60. What my learned friend just read, Lordship, total length of service 29 years, 6 months, 14 days. So as per rule 153(2), Lordship, 21 to 30 years service, Lordship,
1 year's pay.
1 year's pay, Lordship.
Lordship, and that has been calculated in page 60. That is, the pay is 35,600, base grade pay 5,600, total is 41,210 into 1 year's pay, Lordship, that is 4,94,520.
This you are willing to pay.
That,
They
Lordship,
approved.
yes,
Sanction.
provided a sanction comes from the DDO, Lordship, that is the PWD authority. This
No,
is
no,
not,
where is the sanction of the PWD?
Lordship, they,
yes, in the, it's in the writ petition, Lordship.
no, in the
Writ petition also there.
affidavit filed in them, Lordship. Page number 37, it is there, Lordship. The first
37,
first affidavit in opposition.
Yes,
filed
there was the
in
affidavit in opposition. Right.
7, Lordship. This was the original sanction by the department.
what is 37?
Lordship, the office order, according the sanction of rupees 7,56,612 rupees. And the calculation.
This is DCRG.
DCRG, Lordship. The calculation is, the breakdown is in Lordship page number 38, Lordship.
But DCRG you have received,
No, I have not received DCRG. GPF has been.
or GPF.
Yes, Lordship.
Okay.
In page 38, Lordship, the breakdown has been given by the department. The amount is 7,56,612.
Breakup is given on so and so, total length is much.
Lordship.
Then as per so and so, 12 months. 35,610.
Lordship.
DA has been calculated.
Lordship.
DA has been allowed.
Because Lordship, the engineer concern has calculated because similarly situated employees have been given already. They have
Or
paid-
similarly
Oh,
situated employees will not give you a right. The
Lordship.
question is whether the DA is to be included. DA is generally included.
Lordship, it is
No,
included.
no,
because
Lordship,
there is
as
not
per Lordship, I just read the rule. That is not, that has been wrong. That is why the
Lordship, in the
treasury
rule it is
officer
not mentioned that.
has
No,
raised the objection.
rule has not, rule does not
1
say
year's play.
what is the composition of the pay.
Exactly, Lordship.
Yes, yes, composition, Lordship, the breakdown we have given. So in rule, it's only no dearness allowance is written, Lordship. Lordship will see only 1 year's pay. There is no DA.
Mr. Cholia, what is the component of pay?
Exactly, Lordship.
Does it include DNS? It
No,
does
no.
include DNS
Yes,
allowance.
Lordship.
Lordship, no, Lordship.
It's
Here,
1 year.
the calculation, great pay, Lordship, that breakdown only, Lordship, which I'm trying to, here, they've given the breakdown, Lordship. 1 year's pay will include pay and great pay.
No,
In page 16.
that is all right. Why does it exclude the DA?
DA, Lordship.
Lordship, because here,
Lordship, they have not mentioned
That
it.
You have to clarify that DA is not included.
this Lordship, that we have given our calculation.
No, no,
Yes,
that
yes, Lordship, I understand.
calculation is not sufficient.
Why?
DA will have to be included here.
Or I'll produce, Lordship, if required, I'll produce
Lordship,
what
this
all
is the
is to
second
be
time,
included.
Lordship, first affidavit in opposition, no mention now. In
No,
the
no, no.
second,
There-
they have come to a new figure. Now they are
No,
again.
this is the correct figure, Lordship. We have never mentioned, we have never admitted the amount that has been, this is a some sanction order by the,
So as there are judgments where it shows that
Dearness
DA is included in the
Lordship, I
pay.
will place, Lordship, but I have only relied on the similarly situated employees, Lordship.
that
Because
Lordship, negative
the
equality.
department
might
has
come.
mentioned
Similarly
the amount.
situated employees does not give you a right
Yes,
unless
exactly, Lordship.
you say that your right flows from a
Lordship.
particular rule or regulation.
Lordship, I'm accepting that, Lordship, but I could not produce that, and I will produce it, Lordship, but with the one or another plea, Lordship, the finance department is not giving this amount. since
You
last-
produce it, we'll take it up at 2 p.m.
Lordship.
Produce it
Lordship.
today itself.
Lordship, here, if Lordship may have it some other day, Lordship, because I'll also,
Since last
I'll
1
also
year,
try to
Lordship,
produce, Lordship, the exact calculation, the exact breakdown also. Lordship, we have given our calculation, whether DNS
You
or not.
have given your
Breakdown is
calculation.
available,
You
Lordship,
show
in the
us
record.
whether DA is to be included.
the breakdown is already
As per
available in the
the
record.
officer, Lordship, I'll get the specific instruction.
Breakdown is.
What
breakdown is-
instructions? There are no instructions required.
Yes, Lordship.
The DA, no, Lordship, we have given our calculation, yes. If I can just
PWD has given
satisfy
the
your
exact
Lordship, whether DA will
calculation,
be
Lordship.
included or not, Lordship.
You come back at 2.
Lordship.
Get your judgment.
Yes,
Lordship can have it on Thursday, Lordship, I will be,
Lordship.
Lordship, here we have given only some slight
Lordship,
cal.
department has sanctioned the
On
amount. Now
Thursday,
they are
Lordship, I am
objecting,
only
Lordship.
sitting for 1 day sanction.
It is there is no coordination among themselves, Lordship.
Coordination with
The PWD has filed the affidavit and they have clearly stated that it is the amount and the DA is included, Lordship.
no,
They are saying-
Where is that calculation of the PWD?
Yes, Lordship.
that is in
That is,
the writ petition also.
yes, it is annexed in the petition.
Page number?
Lordship, page 38 of our affidavit, Lordship, the breakup of the PWD, page 38.
38 lakh. Okay. This was by the DDO lordship. And they have already forwarded it to the treasury, then treasury objected to it.
Yes, Lordship, we are objecting to the DNS as I have been informed.
All
that-
right, Thursday.
Thursday, Lordship. Yes, DNS allowance, Lordship. only.
Yes, yes.
Yes, Lordship.
Information.
Yes.
Judgments. Thursday on the request made by the council for the parties. Parties will apprise the court with relevant materials as to whether the DNS allowance is to be included in pay while calculating the DCRG. Yes, per the pension rules. Mr. S.K. Mary appears for the union. IG.
Biplab.
Yes, Mr. Sagal.
Well, they actually government to take because they said that government sanction is required. They
Instruction received, Lordship, that Lordship, there are one.
What is your claim?
My claim for regulation, As per the
Regularization.
act, as per the act. My name was not sent. Now subsequently as per order of Supreme Court, to the petitioner's name was sent. And they have to consider it. Act is
How many years of service have you put in?
since 2011 and 13, So the act says, that page 21, the act says, page 22, section 3. The following category of employees are eligible for being considered for provincialization of services. He is an employee of the board, equited on or before 4th September 2000. So they must be before that. So we are there,
Your names have been forwarded.
My name, originally, name in the list was there, but subsequently when the one of the municipal employee, he fraudulently my two petitioner's name were dropped. That is why, we put Surupo. And then, the Surupo directed the chairman, to forward the name. Then chairman forwarded the name, name. And as per the act,
What has happened now?
Lordship, as per our instruction, Lordship, 1044 posts are sanctioned, Lordship. And at this stage, Lordship, it cannot be increased, Lordship, due to the prior approval is required from the government. That's why problem arises.
Is there any provision that sanction is to be?
Lordship, as per Act, Lordship, the clause 5, it is stated that for the purpose of provincialization of service of municipal employees under this act, the government shall create and sanction such number of ex-cadre posts which shall be personnel to the incumbent, Lordship. And government has sanctioned 1044 posts are sanctioned, Lordship. And the remaining posts are
You
not
sanctioned
sanctioned.
it. You send the proposal.
Government approval is required, Lordship.
You sanctioned it.
Government require.
No, the approval will come only when you
Approval-
send the proposal.
yes.
You send the proposal in terms of the section
5, Lordship.
5.
Section 5, Lordship.
You are representing the municipal board.
Lordship.
Send the proposal to the proper department, appropriate administrative department.
Director of Municipal Administration, I may be in, Lordship. Board, he is appeared, Lordship.
So why have you not sent the proposal?
Lordship, the rectified list has been already sent, that is on record.
Mere rectification of list will not do. You have to send the proposal
Well,
for creation
earlier-
of posts.
Earlier employee, they have taken, the dismissal action against them, The person who has committed the mistake.
Where is their proposal? Where is the list of proposal you sent?
Lordship, that's serial number 9 and 10. Both the picking.
What is ULB employees? What is ULB?
Urban local bodies, Lordship.
Urban local. So you'll have to send a proposal for creation of this personal posts. What is your prayer, Mr. Saiwala?
Our prayer should be provincialized as per the act.
So that
So-
has, the proper procedure laid down in the act which will have to be followed.
Yes, they have to take a section from the government.
The sanction will come only when the proposal is there.
Proposal has been sent now.
No,
Now it
no,
is there.
no. Proposal for creation of personal posts.
Yes.
They merely forwarded your names.
No, earlier, my lord, my name was not forwarded. That is why, my lord, this I did not come within 144, 1044. Now, my lord, as per the direction of the Supreme Court, our names were sent. So they have to, my lord, take a.
Where is the direction of the court?
Yes, it is there, my lord.
As per Lordship affidavit is concerned, Lordship, they have stated their names are forwarded, Lordship.
My lord,
Either his name is not forwarded or not, it is not clearly mentioned, Lordship.
my lord, 25 to 26. 25 to 26. What are the 25 to? He had his stand on provisional mistake, my lord. So that is why they have taken dismissal action against him.
What is this communication at page number 50? For what?
According to direct.
You read the covering letter, page number 50. For what purpose is the list submitted?
I contain the, actually the previous list didn't have more of the employees. So the four other employees who actually are curtailed out of the list that was earlier forwarded. Their names are included over.
Reference of this institution is there. Here is the 2nd July list also, but subsequently that
Mr. Ian Saiwala, Leonard Singh Council, assisted by MS. Mr. H. Chakraborty, appearing board,
Respondent number Lordship, 1 and 2 Lordship.
1 and 2, and Mr.
Here, but
A.R. Palvo, respondent 3 and 4. 4, you appear for 4 also, Mr.
Lordship,
Chakraborty.
board has appeared Lordship.
No, why? He's the executive officer.
Lordship, I understand Lordship, but
ACS. He's an ACS officer.
he filed a local number. Local number he appeared.
All right, 4 and 3 and 4. The only grievance of the writ petitioners are employees under the Narayanpur Municipal Board. They are serving as what? What is their service?
LDA and grade 4, my lord.
Serving as LDA and grade 4. On temporary basis, is it? Since their dates of appointment. Petitioners are agreed that in terms of the Assam Municipal Act 1956, Assam Municipal Employees Provincialization Act 2025. The petitioners are entitled to be appointed, entitled to be provincialized in their posts. So
Well, not temporary, regular employee.
they are regular employees. Where is that order?
My lord, that there was one and then my lord, the list was prepared at page 18. So what you see page 18, my lord, the list was prepared. I wanted to submit.
This is for provincialization.
Yes.
So the names of the employees, the petitioners were required to be provincialized under Section 4 of the Act of 2025. So the municipal board forwarded the names of all the employees with a proposal for the government for provincialization of their services under the Act of 2025. So, however, in the process, names of the writ petitioners were inadvertently left out.
Yes.
Being agreed, the present writ petitioners have come before the court. Pursuant to issuance of notice, the chairman of the municipal board has filed their affidavit, wherein they do not dispute that the petitioners are in regular service, and the crucial date for their eligibility for provincialization is 4/9/2013. Stop. However, in the list, which was forwarded by the municipal board, what is the meaning in page 32, para 6? In the affidavit, para 6. "12 to 8 employees of so and so appears to have occurred." What is the meaning?
The reduction of employees from provincialization or the list of 12 employees to 8 employees. But the head assistant is sent later on names of 8 employees, madam, instead of 12 employees.
so initial letter was published on.
No, so
page number 18.
Page number,
we are asking you, what is the meaning
There was
sought
second
to be conveyed by in para 6? Is it a case that out of 12 employees, 8 employees' names were shown, 4 names was inadvertently dropped?
No.
But this is not what is stated in the paragraph.
Yes.
That is what we're saying. The the averments made in the affidavit, it is stated that the petitioner, names of the petitioners were inadvertently left out in the list which was forwarded to the government for provincialization. Stop. Thereafter, during the pendency of the writ petition, by order dated 25/2/2026, the coordinate bench had directed the Narayanpur Municipal Board to place the correct position before the Director of Municipal Administration with regard to the number as well as the names of the employees of the board eligible for having their services provincialized under the provisions of the Assam Municipal Employees Provincialization Act 2025. Stop. In deference to the said order, by communication dated 2nd of July 2021. So it can be in deference to this.
No, not second. That was earlier. Later on, my lord, at page, my lord,
Then
at page 50, 10th March 26.
In deference to the said order, by communication dated 10th of March 2026, the Executive Officer, Narayanpur Municipal Board, has forwarded the list to the Director Municipal Board, Municipal Administration, the list of 13 numbers of employees, which includes the writ petitioners.
Yes.
Where are the names?
9 and 10.
Numbers of
Huh?
No,
Sorry. 15 numbers of employees.
our names are,
Which
Nine
includes
and
the
10.
names of the writ petitioners at serial number 9 and 10 of the same list. Stop. The State Council, Mr. Chakraborty submits that in terms of the proposals received from the various municipal board, as many as how many posts?
1044 posts are sanctioned.
1044 posts are sanctioned for provincialization of urban local bodies employees. So, and accordingly, steps are being undertaken for regularization, provincialization of these employees. So, he however submits that insofar as the writ petitioners are concerned, appropriate sanction or approval is to be undertaken from the department before any steps can be undertaken for provincialization of the writ petitioners as prayed for. Correct. The Assam Municipal
page 21. Page 21.
Assam Municipal Employees within bracket Provincialization Act 2025 was enacted on 13th of June 2025. Stop. In terms of the same provisions of the Act, as per Section 3. Section 3 of the said Act provides for the categories of employees who are eligible for being considered for provincialization of the services. Stop. The said Section 3 reads as under Section 3 extract code. The Section 4 of the said Act provides for provincialization of employees of the municipalities under the state. And Section 5 prescribes for creation of personal posts by the government, which will be ex-cadre posts for undertaking the purpose of, for the purpose of provincialization of the services of the urban local bodies employees like the Deputation. So these ex-cadre posts will be personal posts which shall stand abolished on cessation of the services of the employees concerned. So The section 4 and 5 are also expected. But a conjoint reading of the provisions as extracted above reveals that the Act of 2025 lays down the criteria for provincialization of the urban local body employees. Insofar as the writ petitioners are concerned, they satisfy the criteria laid down in section 3(1). As on date, as per the information furnished in the writ petition and which is not disputed by the respondents, the petitioners were employed with effect from when were they employed? 25/1/11 and 25/1/2011 for petitioner 1 and 16/3/2013 for petitioner number 2. As such, they were both employed prior to the cutoff date of 4th of September 2013. There is no dispute that they are citizens of India or that they are not of sound mental or physical health. There is also no averment in the affidavit filed on behalf of the respondents that there are disciplinary or criminal proceedings pending and that they are insolvent or convicted of criminal offense involving moral turpitude at any point in time. Under such circumstances, upon the names being forwarded to the Director of Municipal Administration, it is now incumbent on the respondent state to undertake the process prescribed under Section 4 for the undertake the purpose reflected in the Act of 2025 for provincialization of the services of the urban local body employees like the writ petitioners. Where necessary, the government is also bound to create personal posts which will be ex-cadre posts and which will be abolished on the cessation of the services of the employees. Where under such circumstances, it is clear that the claims made by the writ petitioners are within the contours of the prescription of the Act of 2025. The municipal board has undertaken the steps for forwarding the names of the persons along with all particular details. The municipal administration for undertaking the process for provincialization. If the number of posts which are sanctioned by the government falls short to accommodate the present petitioners, then the government will forthwith undertake to create sufficient number of personal posts to accommodate the writ petitioners for the purposes of provincialization. As per Section 5 of the Act of 2025, these posts will have to be sanctioned as an ex-cadre post and which will be personal to the incumbents, and same will be abolished on the cessation of services of such urban local body employees. In terms of the mandate of the Act of 2025, the respondent authorities are now directed to take all steps necessary for provincialization of the writ petitioner by calling for all particulars as may be necessary and sanctioning the adequate number of posts and thereafter pass appropriate orders for provincialization of the writ petitioners in terms of the Act of 2025. This process be undertaken forthwith and the posts as directed created as expeditiously as possible within the outer limit of 120 days from the date of receipt of a certified copy of the order. With petition accordingly disposed. Order is to lost. The order if any stand merged pending either for dismissal. Pending.
Well, my learned friend was supposed to. It's a matter, my lord, where there were two inquiry officers were appointed. The subsequent, if a lordship should recollect the facts, in fact, my lord, on 24/7/24, the second inquiry officer was appointed. Whereas in his inquiry report at page number 63, if a lordship should kindly see, at page 64,
Lot Mondal.
Lat Mondal. Now, if a lordship should kindly come to the first subpara, on 8/7/24 at page 64, while later dated, he was served once again with all the documents, he claims of non-receipt, and he has submitted his reply. But since he was appointed on 24/7, therefore on 8/7 he could not have given. But here is a case in my humble submission.
One officer was appointed, he gave a conclusion.
He gave a conclusion.
And there is no
Then
indication whether.
in the affidavit, they take a stand because that report did not appeal to the disciplinary authority. Therefore, another is appointed, which Supreme Court says you cannot. So what logically therefore has to be done in my humble submission is, my lord, let the show cause notice be there. It should start from that, and all these things should be set aside. From the show cause, they will have to start and giving me all the documents, details, everything.
Yeah, Mr.
Yes, my lord, I have gone through the records, my lord. My lord, after submission of the first inquiry report 31/8/2023, and my lord, chief petitioner, my lord, submitted his reply. And so disciplinary authority 8/7/2024 submitted the required documents. In reply, he said that some documents are not submitted. 4 documents. That document is nothing, that's communication. Even though that document has been given after submission of the inquiry
No,
report.
given by who, which inquiry officer?
Not inquiry, but ADC disciplinary authority had sent it.
Disciplinary authority.
Yeah, because these earlier inquiry officer was transferred. Therefore, documents submitted to delinquent.
No, he will request for documents to whom?
Yes.
Before the inquiry officer only?
Yes, well, disciplinary authority, my lord.
How the disciplinary authority?
My lord, inquiry officer, first inquiry officer. No, my lord.
Where is that sequence? Show us the sequence of documents. Where is it?
Yes. Document submitted to delinquent 8/7/24.
8/7/24.
Four.
Submitted by whom? Furnished by whom?
ADC, Kamrup.
ADC Kamrup. ADC is the disciplinary authority.
Disciplinary authority.
Sorry.
So, my lord, next, when he submitted his reply. In reply, he said that, my lord, some documents are not given to me. That's why I should be provided this document. So, document has been given. The cause of action arises that that's why, my lord, next, my lord, Biswajit Soikia appointed to complete the, my lord, this departmental proceeding. Otherwise, it would not. That's why, my lord, this is a continuing process, my lord. Biswajit Soikia is appointed to complete the my lord, remaining portion of the departmental proceeding, which was my lord, submitted to the petitioner the documents, 4 documents. A delinquent replied after 4 documents ADC on 18/7/2024. And Biswajit Soikia, that appointment next inquiry officer submitted report 3rd of October 2024. And 3rd of but there is an inquiry report also provided to the delinquent officer on by 26 November 2024. And delinquent officer submitted reply this against this 3rd October 2024 submitted by the inquiry officer. So this is a continual process. There is no appointment of otherwise second officer. The petitioner himself invite to continue with the departmental proceeding because he claimed, my lord, his claim is in reply, my lord, page, my lord, I am 70. Not an, my lord, a deed of it. And page 88, but these documents are ballot in the records. WT message 25th October 2018 received from the superintendent of police.
Come to page number 63. 63.
Yes.
Read the last line.
Last line, madam, is regard the mentioned that the inquiry officer, journality party, it is confirmed. Metro has already submitted inquiry report on 31st August 2023, where the delinquent official was found guilty as charged. The copy of the inquiry report was served upon the delinquent official on 10/6/2024 and the 10/6/2004. However, the 18/6/2024, the delinquent official has raised objection to the inquiry report on the following grounds. These are the grounds, my lord. He was not furnished the documents on the basis of which so-called notice was served to him. He was not furnished with the documents on the
No,
basis of
what we want to say is, you say the inquiry was not complete.
not complete because my lord,
But this is what the subsequent inquiry report officer has given a finding.
findings are only on the basis of earlier inquiry report, and he only see the but not only the documents. What would be the reply of the delinquent officer? And that's why that second inquiry officer has seen it. The earlier inquiry officer has done all these things, and he reaffirmed it that there is no new fact is given by the delinquent officer in the reply to after received the 4 documents. That's why he has concluded it, madam, in view of the above. A careful examination of the documents presented, nothing contrary was found against the report submitted by the inquiry officer on 31st date 2023. And the charges framed against the delinquent official is reconfirmed and action may be initiated accordingly. That is his reconfirmed because only because of 4 documents which was not provided to the petitioner, subsequently provided after giving the first inquiry report. That's why cause of action arises due to appoint Biswajit Soikia to complete it. This is appointment letter, Lordship, page 62.
The appointment letter is okay, but the subsequent inquiry officer has given a finding. Has in his inquiry report stated that the inquiry report by the earlier inquiry officer was already submitted.
Submitted.
Then where is the question of completion?
After submission of the inquiry report, the inquiry report was provided to the delinquent officer.
Ah.
The delinquent officer submitted a
No,
reply.
delinquent officer, you may raise grievances, but doesn't mean that you'll again open the inquiry.
No, my lord, he has complained that documents were not given to me. That's why for fair
Now,
proceeding.
in response to this, where is that order of the subsequent inquiry officer being appointed?
Page 62. Lordship.
62. Now, in regard to 62, is there any relevant material on the record to show
No,
that why this person was required to be appointed?
yes, only because of the 4 documents, my lord, that was he sought for.
But this is not the procedure contemplated under discipline and appeal rules.
No, my lord, this is what happened. Had it been not submitted, not claimed to the authority that 4 documents are not given to me to give proper inquiry, proper reply to the against the inquiry. That's why the 4 document has been given to the delinquent officer. And in the meantime, my lord, first inquiry
Under
officer.
the rules, you are following the rules only.
Yes.
The discipline and appeal rules. Discipline and appeal rules, you issue the notice, show cause. They'll give all replies, documents, list of witnesses. They'll give a reply. Then they're not satisfied. Inquiry officer is appointed. Inquiry officer conducts the inquiry, submits a report. Now that report, a copy of which, if the authorities of the view that you would like to impose a punishment on this, or would disagree, then a copy is to be issued to the delinquent officer.
That is the procedure, my lord.
Right.
But there is no bar
to subsequent to complete inquiry.
So
Inquiry.
why do you say
So-
complete?
no,
Because
that is that is
because both the inquiry officers,
Yes.
both the earlier inquiry officer has also submitted this
inquiry report.
inquiry report.
Yes.
It does not say that the inquiry is incomplete or further inquiry is required to be done or anything like that.
Oh, that is why, my lord, he replies there, my lord, the report is there.
In fact, if you come to page number 49,
Yes.
there is a clear finding by the earlier inquiry officer that the delinquent government servant is found guilty on the ground of misconduct, which caused embarrassment to the government and demean to the public service. This is the finding.
Yes.
So this finding could not have been arrived at unless the inquiry is complete.
So, my lord, I am giving one of the report, my lord. 62 his reply, my lord. His reply submitted by the lord delinquent of the 18/6/2024 to the lord ADC. And outset, said so and so report. That, sir, in connection with the DP 11/2018, I was so caused by the so called notice dated 10/8/2021, wherein I specifically stated that no documents were furnished to me on the basis of which so called notice was served. In spite of the aforesaid fact, and in spite of the fact that no documents had been submitted to me, inquiry had been conducted against me, which itself makes the inquiry illegal. For this purpose, my lord, submitted 4 documents which were sought for by the delinquent officer. The 4 documents is nothing, my lord. They are only, my lord, I am reading the
And the first inquiry officer, he even went to the extent of imposing penalty or compulsory retirement.
that is true, my lord.
And
That,
how penalty can be imposed if the inquiry is not complete?
no, that only because of his reply, my lord.
Inquiry has to be complete.
Complete, my lord.
Now, if he has submitted that these documents are not there with me, then there has to be a proper finding by the disciplinary authority that the inquiry conducted was not as per rules. We are going for a fresh inquiry.
But that was not done. But only because of his reply to give a fair proceeding and justice to the delinquent officer.
So you start from the level where these documents are given, because you see there are 2 inquiry reports now.
Yes.
Even the second inquiry report makes reference to the first inquiry report, and the second inquiry report has relied on the first inquiry report. Say that the earlier inquiry officer had submitted the report wherein the delinquent was found guilty as charged. There is a
Findings is there, my lord.
finding is there.
That is true. So let it be, my lord, start again from the stage, from the so-called.
The show cause has already been issued.
Already issued.
Reply has been filed. Now you start the process of inquiry afresh.
Inquiry afresh, my lord, yes, my lord, including the 4 documents, my lord.
Keeping the petitioner under suspension.
Yes. In suspension.
Team suspension. That's it. Yes, Mr. Chaudhary?
Yes.
Heard?
Let's, okay.
Anything you want to say?
All that I wanted to say was, actually, mother, what is the charge against?
Those you raised before
Yes,
the authorities.
yes, yes.
Charges there, my lord.
Because if you are going for a fresh inquiry, then the question of whether charges are definite, indefinite, etc.
Exactly. Then I can raise those points.
Heard Mr. K.N. Chaudhary, Learner Senior Counsel, assisted by Mr. T. Devi and Mr. C.C. Sutia, Senior Counsel, assisted by Ms. J. Sharma and Mr. J. Hendick for review. So the petitioner before the court was serving as Lord Mondal. under the Revenue Department. You were serving as a Lat Mandal, is it?
Not now,
LRA, Land Record Assistant, Land Record
assistant,
Assistant.
new designation.
Lat Mandal, subsequently redesignated as Land Record Assistant, LRA. Stop. In connection with an allegation that the petitioner demanded and received a bribe during his official duties, a departmental proceeding was initiated. Is there a criminal matter also?
Yes, yes. Thank you.
An FIR was lodged, which had culminated into a criminal proceeding. And departmental proceeding, being DP number 11 of 2018, was also initiated against the writ petitioner. So, a show cause dated 10/8/2021 was served on the writ petitioner, asking him to reply, leveling allegations against the petitioner that he demanded and received bribe, and giving an opportunity to the delinquent employee to submit his reply to the show cause issue. So, where the learned senior counsel submits that the show cause did not contain the list of witnesses and or the
List of documents.
list of documents. Nevertheless, the writ petitioner submitted his reply and also requested for furnishing of the relevant documents. So, it is the submission on behalf of the petitioner that without furnishing these documents, the inquiry officer was appointed and the inquiry officer conducted the inquiry and submitted the inquiry report dated 31/8/2023, holding the petitioner guilty on the ground of misconduct which caused embarrassment to the government and demeans the public service. Stop. The inquiry officer went to the extent of penalizing the delinquent officer with penalty of compulsory retirement. So, the petitioner, meanwhile, submitted, the petitioner thereafter was served with a copy of the inquiry report, and in response, he submitted a reply to the disciplinary authority, namely the additional district commissioner, Kamrup Metro District, disputing the conclusions arrived at by the inquiry officer appointed. Stop. In the same reply, he also raised the issue of non-furnishing of the relevant documents and being denied the opportunity of cross-examination of the witnesses. So, in response to this reply, the petitioner was furnished documents in connection with DP number 11 of 2018 only on 8/7/2024. Petitioner again submitted a representation before the disciplinary authority requesting to reject the inquiry report as the same was conducted and the conclusions were arrived at in violation of the procedure mandated. It is submitted that upon consideration of it is submitted that thereafter the disciplinary authority appointed another inquiry officer purportedly for completion of the departmental proceeding as the earlier inquiry officer stood transferred. The subsequent inquiry officer thereafter again submitted another inquiry report dated 3rd of October 2024, holding both the charges made against the writ petitioner to have been proved. And the petitioner and it was held that the charges framed against the delinquent official is reconfirmed and action is to be initiated accordingly. Stop. Learned Senior Counsel has referred to the Learned Senior Counsel in his submission has made reference to the said inquiry report dated 3rd of October 2024, wherein the second inquiry officer had also relied upon the conclusion arrived at by the earlier inquiry officer, and which itself on which ground itself the inquiry report submitted by the second inquiry officer ought to be rejected. Stop. Subsequent to the inquiry, second inquiry report submitted, the disciplinary authority by the impugned order dated 10/1/2025 imposed the punishment of dismissal from service, being agreed the present petition this court. Where Mr. T.C. Sutia, learned additional senior government advocate, as also Mr. J. Hendick, counsel representing the Revenue Department, strongly opposed the contentions of the counsel for the petitioner. Stop. It is submitted that there is no infirmity in the inquiry conducted against the writ petitioner. Stop. It is only in view of the fact that the earlier inquiry officer stood transferred, that the subsequent inquiry officer was appointed for completion of the inquiry officer, and which is evident from the recital of the order dated 24/7/2024. Stop. It is further submitted that in view of the representations or replies issued by the submitted by the petitioner that the relevant documents were not furnished, the copies sought for by the petitioner was duly furnished to the writ petitioner on 8/7/2024. Stop. Thereafter, the inquiry was completed and ample opportunity was granted, but the inquiry, the inquiry officer, and thereafter the inquiry officer came to the conclusion that the charges against the writ petitioner level have been proved, and action was recommended. Stop. This inquiry report having been accepted by the disciplinary authority, the impugned order of dismissal was issued. Data line 31. Contention of the counsel for the petition is that subsequent inquiry is a de novo inquiry initiated against the petition, which is not permissible in law, and is also under the rules. In support of his contentions, he has pressed into service the judgments. What were the
Yes,
judgments?
I relied upon two judgments, my lord.
KR Dev
And my lord, 2014 10 SCC 589, Vijay Shankar Pandey versus Union of India.
to ask Mr. Devri, please submit
Both the copies.
the citation relied on the judgments of KR Dev and so on in support of his contention. Mr. Chutia, as also Mr. Hendick, in view of the submissions made, strongly disputes the contentions raised that there was any de novo inquiry initiated against the petitioner. Stop the
Milan, and in the affidavit, they clearly say at page 72 that it was appointed because he was not satisfied. Not being satisfied with the inquiry submitted by Jharna Jyoti Patgiri, that had to appointed a new inquiry. Page 72. This is what Supreme Court says cannot be done.
paragraph.
Paragraph on top, Milord, further in middle on top. Further, not being satisfied with the inquiry submitted by so and so. That is what has been deprecated in KR Dev and Vijay.
Is by respondent 4.
Yes, it's an affidavit by respondent number 4. It's a third page, Milord. On top, fifth sentence, further not being satisfied. That this is something, Milord, it cannot be. There can be a further inquiry. There cannot be any Milord, new inquiry or a de novo inquiry. It is the stated stand.
The senior counsel therefore submits that the averments made in the affidavit make it clear that being dissatisfied with the earlier conclusions of the inquiry officer, department had appointed a new inquiry officer to complete the proceedings. Stop is submitted that this action of the respondent is in conflict with the judgments, the law laid down by the apex court in Provincial versus. The learned counsel for the parties have been heard, pleadings available on record have been carefully perused. There is no dispute that there was an inquiry officer appointed earlier to initiate the inquiry departmental proceedings against the petitioner. The inquiry officer was appointed on 17/7/2023, and the state inquiry officer had submitted a report on 31/8/2023, which is enclosed to the writ petition. Stop. A careful perusal of the report reveals that the inquiry officer had come to the conclusion that the petitioner was found guilty on the ground of misconduct which caused embarrassment to government and demeans the public service. Stop. The inquiry officer even went to the extent of imposing penalty of compulsory retirement on the writ petitioner for his offence. Stop. Claims of the made by the contentions raised by the petitioner that prior to the conclusion of the inquiry, the relevant documents and the list of witnesses were not furnished, although not specifically, although disputed by the respondents. However, from the records, it could not be pointed out that the same was furnished to the petitioner prior to the submission of the inquiry report dated 31/8/2023. Stop. However, on the basis of the reply and the representations filed by the petitioner ventilating his grievances that the inquiry was not conducted as per the procedure, the relevant documents were not furnished to the petitioner, nor was he given an opportunity to cross-examine the witnesses. It appears that the department proceeded to appoint another inquiry officer purportedly for completion of the departmental proceedings by order dated 24/7/2020. So it appears to the court that the contention raised by the petitioner that the subsequent inquiry officer was appointed because the department was dissatisfied with the earlier report submitted by the inquiry officer. It appears to be a correct position on facts in view of the clear averment in the affidavit filed by the Deputy Commissioner, namely respondent number 4. What is the District Development Commissioner is what? Not Deputy Commissioner.
Not Deputy Commissioner.
The District Development Commissioner, respondent number 4. At para 4, where there is a clear averment that not being satisfied with the inquiry report submitted by Srimati Swarna Jyoti Patgiri CS, Lead and ADC and Inquiry Officer of the said department proceeding, the District Commissioner being the disciplinary authority, Kamrup Metropolitan District, had appointed a new inquiry officer for completion of the proceedings. So, better. The procedure laid down under the discipline and appeal rules, so far as Rule 9 is concerned, is very categorical. The entire process by how a departmental proceeding is to be initiated against the government officer is clearly delineated under the rules. The procedure mandated under the rules has to be compulsorily followed if the proceedings are undertaken under the same rules. Stop. There is no quarrel on the factual position that the petitioner being a government servant is governed by the procedure prescribed under the Discipline and Appeal Rules 1964. Stop. Coming to the judgments, coming to the judgments pressed into service by Mr. Chaudhary, Senior Counsel, it is seen that in KR date so and so, the apex court held that while there is no strict restraint on the department for initiating a de novo proceeding, if it appears to the authority that the procedure prescribed has not been followed, ordinarily, the de novo proceeding cannot be initiated if the conclusions arrived at by the first inquiry was found not acceptable to the departmental proceedings. Stop. You relied on KRDEP.
KRDEP and Vijay Miller.
Okay. What is the KRDEP judgment? It is referred here, I think.
Yes. KRDEP is referred in Vijay Miller. KRDEP para 12.
In Vijay Shankar Pandey, they say the law enunciated by the apex court in KRDEP has been reiterated by the apex court.
Para 25 and 26.
Relevant paragraphs are extracted. What is Khatri for?
Khatri was found, my lord, that the police report cannot be relied upon. That issue, lordship will keep it open.
Then we are not relying on Khatri.
Khatri.
So a KRDEP and Vijay.
Vijay.
The law laid down by this judgment of KRDEP has been followed in several, has been followed extensively by this court, by other coordinate benches, reference of which may be made to at this stage. Judgment get out. A perusal of the law makes it clear that while under the discipline and appeal rules there is no provision for a de novo proceeding, yet if it appears to the authorities that the procedure mandated under law was not followed, and in order that no prejudice is caused to the delinquent officer, the inquiry is to be conducted afresh. Then a fresh inquiry or a further inquiry or a de novo inquiry to overcome the lacunas cannot be treated to be on the same footing as a de novo inquiry instituted by the authorities, merely because the conclusions of the earlier inquiry officer was not found favorable by the disciplinary authority. Stop. In the facts of the present case, the earlier inquiry officer proceeded to the inquiry and concluded by giving its findings on so and so date by inquiry report, and also imposed the punishment of compulsory retirement. Stop. In the subsequent inquiry, which was instituted by appointing a fresh inquiry officer purportedly for concluding the departmental proceeding, there is a clear reference to the earlier conclusions arrived at by the inquiry officer, which stop. This is evident. This reference makes it clear that the earlier inquiry officer had also been influenced by the conclusions arrived at by the earlier. The subsequent inquiry officer has also been influenced by the conclusions arrived at by the earlier inquiry officer. Stop. Such action is not permissible or contemplated under law. The under the provisions of the rules of 64, if the disciplinary authority was not satisfied that the procedure mandated by law was not followed by the inquiry officer, then there were ample opportunities for the disciplinary authority to make necessary amends to the lacuna which may have crept in. So, however, it appears from the pleadings available before the court that the disciplinary authority had attempted to appoint the second officer purportedly for conclusion of the department proceedings in the face, without there being any explanation, in the face of the conclusions arrived at by the first inquiry officer by the inquiry report dated so and so. Under such circumstances, this court is of the view that the manner in which the department had conducted the inquiry against the petitioner is expressly illegal and contrary to the provisions of the rules of 64, read with the law enunciated by the apex court as also followed by the Gauhati High Court. Stop. The conclusions of the departmental disciplinary authority and the conclusions of the inquiry officer dated so and so, and the consequential order passed by the departmental disciplinary authority therefore stands interfered with, set aside and quashed. The matter is remanded back to the authorities, and the department will now initiate direct initiation of departmental proceedings or inquiry by the inquiry officer, who's a freshly appointed inquiry officer, by giving proper notice to the petitioner. Stop. The relevant documents, list of witnesses, and all other materials which are required to be relied upon during the process of inquiry must be furnished the writ petitioner by proper official communication. Stop. If the writ petitioner wishes to file any reply upon receipt of these materials, then adequate opportunity within the time specified by the department, the respondent authority will proceed for a fresh inquiry against the writ petitioner and thereafter submit the necessary report. Stop. Needless to say, the prescriptions under Rule 9 and 9A of the Discipline and Appeal Rules must be adhered to by the department. Stop. With the above observation, the writ petition stands closed, disposed of. During the period, the petitioner, in view of the interference of the order of dismissal, and during the process, the inquiry is to be conducted, the petitioner will be kept to be under deemed suspension, and he'll be entitled to subsistence allowance as per rules.
Lord, the issue regarding the maintainability of the charges is kept open. Otherwise, tomorrow there will be not constructive
The,
resolution.
the petitioner is permitted to raise raise his defense before the
Including sustainability of the charges.
before the departmental authority, including the maintainability of the proceeding.
Yes.
And the charges.
Deep level.
Records placed are returned back to the government council. Yes.
I'm hearing item number 21. Can that be taken up on 19th, madam?
Mentioning at 10:30.
I don't know, madam. I was here, but long time.
You are still here.
Yes, yes.
Uh,
Some personal accidents has come up, my lord. I have to leave the court. That is why I'm making it.
you ask your colleague to be present, who's there?
My lord,
Mr. Borua is there, he will make a necessary mention as and when the matter is called up. So we can't help that. There are councils, all right, Mr. Chaudhary is not there, then it's all right, but we can't. If we give you that liberty, we have to give liberty to all. And we have to say that, all right, mentioning will be throughout the day.
no, madam.
Then
Personal accidents, sometimes there is.
you leave, we are only asking your colleague to be present, that's all. He will make the submission. He will make the submission, or somebody else on your behalf will make the submission. And consider it.
Have some urgency in this matter. Online.
You urged it.
Yes,
21.
because post is.
We are not giving an adjournment to now, as and when the matter is called up.
Online.
No, not 19. We are not giving a date. As and when the matter is called up. We are not making any commitment that we'll adjourn the matter.
Kindly consider that aspect.
We will consider it, but we are not committing.
He has informed me that matter will be taken up on day after tomorrow.
We don't know. Let us see. Any mentioning is there at 10:30, you make a mention. What is it?
Not there now.
That's all right. We'll excuse you. Ask somebody to be present.
Is challenging a transfer order. It's otherwise a armed force, the scope of interference perhaps is in a very narrow window. But my submission is that it is before the standing orders which govern summer chain transfer.
Why?
Because the standing order mandates that to be subjected to a summer chain transfer, an officer has to serve a certain number of years, then it's defined as a tenure at a particular post. Definition of tenure itself provides, regardless of your substantive posting at a certain area, if you are temporarily posted or attached to some different area for a period beyond 90 days, then your tenure will be counted against that area, not against your substantive posting. So the affidavit, the ground that they have stated, the respondent authorities, they have stated that since his substantive posting was in Assam for the last 4 years, therefore he has been subjected to a summer chain transfer. But the records would show your lordship that during this interim, this period, for more than 400 days, he was serving in Chhattisgarh in different areas. So he is not covered under the definition of tenure as per the standing orders holding.
No, we don't get you. You are posted where now?
My substantive posting is in Assam
Right.
now also. The standing orders governing summer chain transfers say that to be subjected to a summer chain transfer, you have to serve for a minimum period of 3 years at a certain place. Now they have issued a order, the impugn order, by which I have been transferred to Odisha. My plea in the petition was that I have not completed the required number of years to be subjected to a summer
What
chain
is the required number of years?
3 years.
You are not there in Assam for 3 years.
No. So they have come up with a response saying that my substantive posting, my unit basically was in Assam during this period. But the records would reveal that I was temporarily attached different areas in Chhattisgarh during this period. the definition of the word tenure as provided in the standing order itself says that if I am attached temporarily for more than 90 days, Your Lordship, to any other area, my service in that area will be counted and not in my substantive posting in Assam.
Where is that definition?
My lord. My lord may have the definition of tenure at page number 76. Your Lord. It's at the bottom of the page. Tenure means the period of continuous posting in a particular station stroke area stroke region stroke NCR, including government duty stroke attachment beyond 90 days. In case any official is on attachment stroke temporary duty from a specific area for more than 90 days, the period of such attachment stroke temporary duty will be counted towards tenure of that specific place where is attached or on temporary duty. So my unit was no doubt in Assam, Your Lordship. But I was in Chhattisgarh.
So you were on attachment for how many days?
A total of 559 days in the concerned period.
So therefore, your place of duty is to be counted towards Chhattisgarh,
Chhattisgarh,
not Assam.
not Assam.
Notwithstanding that your unit was placed.
Yes.
Right. And what is the stand of the department?
Stand in affidavit, they have stated that since I was, my unit was there in Assam, I was substantively transferred to Assam since 2021 onwards. I have exceeded the required number of years for a summer chain transfer and I require to be transferred out.
This does not appear to be correct on the report.
Lordship, there is, it's stated that if it is beyond 90 days. So it's not that he is in Chhattisgarh for a continuous period. Some days, only 3 occasions, it's beyond 90 days. 94 days, 91 days, and once 149 days. That chart is annexed by him in his affidavit in reply. So if those period only has to be counted as a part of Chhattisgarh because it's beyond 90 days. If we leave that part also, he had already that required more than 3 years.
He says only 2 years.
No, this is only on medical ground.
Huh?
If Your Lordship has my last transfer,
Uh.
because it does not make any exception for medical grounds. My last transfer
No,
was
there are some exceptions.
yes, my lord. No, presently it's a summer chain transfer.
Uh.
My last transfer to Gauhati was on medical grounds because I was categorized as a low medical category.
His earlier transfer is 21
Yes.
12/2021.
Where even if we count from that area, that period, Your Lordship, period of 559 days, Your Lordship will have to be deducted. And they are saying their understanding is that I have, because the requirement is continuous. If Your Lordship has the definition of tenure, once again, it says continuous posting in a particular area. Tenure means the period of continuous posting. So if there are breaks in service, Your Lordship, for example, my learned friend has very fairly said that I have been posted for at least on 3 occasions for more than 91 days, total of 559 days. Only then I can be subjected to a summer chain transfer.
Because this tenure means the period of continuous posting in a particular station or cluster or NCR, including government duty attachment, etc., beyond 90 days. If it is beyond 90 days also, then also it is a continuous posting. But that 90 days, Lordship, will be beyond 90 days will be counted. Continuous part will remain, but that 90 days or beyond 90 days period will be treated as a, this is also stated that, Lordship, in case any official is an attachment or temporary duty outside a specific cluster. He is in Assam and Meghalaya cluster, but cluster for more than
So
90 days.
you have to deduct that period in Chhattisgarh for more than 90 days.
Yes.
From the continuous
period.
posting area
Yes.
in Assam.
Assam.
And even after that, he satisfies
Yes.
that.
Lordship, that is not the reason that they have given in the affidavit. Now, if that is the plea taken, they have the authority concerned has to apply its mind to those reasons. Your Lordship. This in the affidavit they have stated something else, and that is the reason which they will be bound by. Your Lordship.
What is that?
They say
Yes.
so. If I may take Your Lordship to the standing order first.
Hmm.
Standing order starts at page number 76.
Yes.
And what a summer chain transfer is, your lordship, is defined at clause number 5 at page number 77. at the bottom of the page. It's clause 5A. Subject. Summer chain transfers will cover the transfer cases of officers, officials, personnel who have completed, completing prescribed tenure at a particular unit, establishment as on prescribed cutoff date. Now, what the tenure is, your lordship? A normal tenure is, your lordship will have at page number 81. So we are covered by clause 8A1B. 3 years for all except above. Now, normal tenure. Though they have in the affidavit said that it should be 4 years, but perhaps if there is some correction to the standing order, it is 3 years. Be that as it may. If your lordship now has the definition of tenure.
No, where does it say 3 years? 3 years.
3 years. 3 years. Field battalions in category B and C, SDG, PDG, VIP security battalions, 3 years for all except above. We do not fall in
Exceptions.
my law. So, if your lordship has the definition.
But where is the calculation to show?
My lord, I am carrying the calculation with me. If I may just take your lordship to the definition first of tenure. I have answers for both the arguments raised by the authority. The definition of tenure is, tenure means the period of, I'm reading from page number 76. Tenure means the period of continuous posting in a particular station, area, region, NCR, including government duty, attachment, etc., beyond 90 days. In case any official is on attachment, temporary duty from a specific area for more than 90 days, period of such attachment, temporary duty will be counted towards tenure of the specified place where he is attached on or on temporary duty. So now the first requirement is that he should be, to qualify for that period of 30 days, it has to be a continuous posting of more than 90 days, your lordship. And secondly, if he is posted, temporarily posted or attached in any other area for periods more than 90 days, then your lordship, his tenure will be counted towards that area. Now, if your lordship has the posting details of this officer, which is a part of his service record, which we have brought on record by way of the affidavit reply, it starts at page number 121. So there is no, at least the admitted position is on 22/12/2021. He was his unit was posted to Assam. He was in Assam, Dolgaon. So, but his posting details, your lordship will have at page number 1. They start at page number 125 onwards. Posting particulars, serial number 35. If your lordship has item number 15 and 16 at the bottom of the page.
You are referring to page?
Page 125. I am now posting particulars at serial number 35. Now, if your lordship has item number 15 and 16 at the bottom of the page, so on 22/12/2021, he was brought to Dolgaon, Assam.
15 and 16 is punishment details.
At page number 35, your lordship. Page number 125, item number 35, posting particulars.
Item number 35.
Posting particulars. There is a chart, your lordship. Page number 125, it is a part of our affidavit. Now, if your lordship has his posting details, item number 15 at the bottom of the page, he was in Dolgaon, Assam. There is no dispute to that fact. Immediately, your lordship will see from 26 December 2021 to 2nd February 2022, he was at Basaguda, Chhattisgarh.
That is a period of 39 days. Then if your lordship, please to turn over the page on the next page. Again, item number 18, from 8 May 2022 to 6th August 2022, he was again at Basaguda, Chhattisgarh for a period of 91 days. Then again at serial number 20, he was again at Pegrapalli, Chhattisgarh from 14th October to 20th November 2022 for a period of 38 days. At 21, he was at Nambi, Chhattisgarh from 21 November 22 to 18 January 23 for 59 days. Then at serial number 23, your lordship, he was again at Pegrapalli, Chhattisgarh from 12th October 23 to 11 July 23 for a period of 91 days. Again at serial number 25, from 8 October 23 to 6 January 24, he was in Chhattisgarh for a period of 91 days. Then finally from 31 Jan 24 to 28 June 2024, he was again in Chhattisgarh for a period of 150 days this time. So cumulatively, your lordship, that comes to 559 days. I've just prepared a small chart for your lordship's perusal. So from 22/12/2021 to 22/12/2025, that is the date of issuance of the impugn order, is a period of 1,461 days. Out of these days, 1,461 days, he has spent 559 days in Chhattisgarh. So only 902 days he has spent in Assam. So even if we say that its requirement is 3 years and not 4 years, it's only 2.47. So he's not supposed to be subjected to a summer chain transfer. Otherwise, my primary argument still is that it requires to be continuous posting. But even if we test the other argument, even then it is not met.
Yes.
So lordship, that tenure, page 76, lordship, I am reading it again, lordship. Tenure means the period of continuous posting in a particular station, area, region, NCR, including government duty, attachment, etc., beyond 90 days. In case any official is on attachment temporary duty from a specific area for more than 90 days, the period of such attachment temporary duty will be counted towards tenure of the specific place where he is attached on or on temporary duty. So in that way, only 3 occasions it was more than 90 days, lordship, because the continuous part will remain, lordship. From 20 to 12/21, he was in Assam, and from thereafter, all along he was on. It's not that he was sent to any other battalion. 210 Battalion Cobra. All along, lordship will see serial number 2 of the column that he was associated with 210 Battalion. Sometimes for administrative reason or for other reasons also, lordship, some persons were sent to duty. Then again they come back to their original case. The other persons were sent, and that is how this followed, lordship. That is why if they, because some parts are hard area, some are soft area, lordship, for counting those things, lordship, these, if someone had worked there or in duty for more than 90 days, it will be counted as a for that area, lordship. Because, and that my affidavit is, lordship, specific regarding some amended.
No, in the chart which they have given,
Yes,
page
sir.
125,
Yes.
126, these are the periods where he is stationed in outside the state.
Lordship. Not all outside this case, it's both. This-
Both. Some of them
Yes.
are outside the state. Now, you are saying that notwithstanding his posting outside state, he does not satisfy the tenure because it was not a continuous posting.
That's their argument.
Okay. What is your argument?
It is a continuous posting, and if it is beyond 90 days, then it is to be counted for specific purpose or attachment.
So therefore, what you're saying is if the posting outside the state is for 90 days,
Beyond 90 days.
beyond 90 days, only then it can be
Yes.
treated to be continuous
Yes.
posting. No, from these 125, 126, which are the periods which is more than 90 days?
Lordship, it is stated, lordship, serial number 18.
18. Then,
Sorry, 17, 18, and
no, 17.
1794 days, 3 months, 4 days.
if we only take the periods beyond 90 days, Your Lordship, it would be serial numbers 18, 23, 25, and 27.
No, not 23.
18?
17, 18, and
23 also?
27.
20,
No, 17 is within the state.
17 is within the state.
within the state.
So
It will be
18,
18, 23,
23,
25,
25,
and 27.
and 27.
Now, even if we take that, I thought such a argument would come, Your Lordship. Even if we take that figure, the total comes to 1038 days, Your Lordship. It is still less than the requirement of 1095. Even then, it is not 3 years.
So what will be the number of days in these thing? And this would be 18 would be what, 91 days?
It will be. I'll just give Your Lordship.
91 days.
Yes, 18 is 91 days.
91 days.
23 is also 91 days. 25 is 91 days, and 27 is 150 days.
And we have to count it from 21/12/2021 till
Yes.
date, Lordship.
Not till date, Your Lordship, till the date of issuance of the transfer order.
But it's not yet.
No,
It's
transfer orders.
only transfer order
Transfer orders issued, Your Lordship.
10/2.
10/2. It cannot be till date.
10/2/26. But he still, that was not given effect to.
So totally it is about 423 days.
Yes, it will come down, Your Lordship.
423.
Yes. Then the number of days that can be counted, Your Lordship, would rise to 1038 against the total requirement, minimum requirement of 1095. Even then it is less.
So if it is below that period, I mean these earmarked periods of 91 plus, 90 days plus,
Days plus.
you'll have to be given the benefit by deducting this period from the period he has spent here. These 90 plus days
Lordship.
which he has spent, you'll have to treat it to be continuous posting for more than 90 days,
More than 90
which will have to be attributed to that area. So that will have to be deducted
Lordship.
from the posting, days of posting he's had in Assam. So as per the calculation, he says, even then there'll be a shortfall of less than 3 years.
In that, Lordship, I have not calculated total. I have only.
My
Yeah,
friend has just instructed me. It's actually 4 years. They are correct because he is a general duty officer. General duty officer.
No, it's not 4 years.
The affidavit also does say
We
it's 4
say
years,
that
they are correct.
it is actually 3 years, but he has
No.
spent more than 4 years.
Lordship will see.
Lordship.
4 years for group B, C, and general duty stroke signal person.
Page 96, I have
Petitioner is
stated.
a constable in the general duty category. Even otherwise, even if we take it as 3 years also is.
In page 96, I have stated the petitioner has already been completed more than 4 years of tenure in a cluster of Assam and
Very
Meghalaya state continuously.
Exactly.
As per existing instruction, normal tenure is 3 years and he has already exceeded the prescribed period of posting in Assam.
Very
So
well.
it's 3 years for us.
Even if it is 3 years, Your Lordship, it's
Lordship, I have to calculate the total from 20. Once I have to.
Calculate,
Lordship.
calculate and take it up at the end of the list or
Lordship.
maybe day after.
Lordship, I just have to give that because as per our this
You see if you can calculate and get your.
Dear Lordship.
We'll call it up after a while,
Lordship.
after some time. Yes. Yes, Mr. Sharma.
If I may, yes, let the petitioner in person, my lord, see whatever submission he has to make. And the other side also. Day after tomorrow, I shall, after hearing both the parties, I shall make my submission. Next Tuesday, my lord.
Next week. You'll only address us on the legal issues
My lord.
with the minimal facts if required.
My lord, last time I was sorry that I was wrong. No FIR was lodged by the petitioner against the officials of the respondent commentary, but somebody else had done it, which he had mentioned in his writ petition, but that's not connected with this list before your lordship.
We'll hear you. That. Yes, Mr. Board.
In the last occasion, Honorable Court allow me to go through the departmental records. If this Honorable Court from 2023, this Honorable Court passed 4 numbers of court orders by ordering the respondents to submit their departmental records. In Lordship, last order dated 28/01/2026. Can you refer to the order dated 28/01/2026? It is mentioned that the respondent in the NRL shall produce the original records pertaining to the departmental proceeding.
28/01/2026.
Prior to that, 3 orders were issued, but they did not follow those orders also.
Yes.
In this order, it is specifically mentioned that NRL shall produce the original record pertaining to the departmental proceeding as well as appeal proceeding. Lordship, last occasion I have gone through the document that they submit, but those documents pertaining to the departmental proceeding only, they yet not submitted appeal proceeding as well as some other documents also. They are still.
No, what record did you go through?
Yes, Lordship.
The original records.
Yes, original record, but maximum document I have already annexed along with my writ petition.
Okay.
Kindly allow me to apprise those documents so that the respondent can also cross-check at their end. The first document in the departmental record, there is no serial number. That was why I'll go by every document. First document is 03/09/2021. Enquiry officer addressed to the respondent Subrata Das, that I already annexed at page 569. The second is the enquiry report that I already annexed at 570 to 579. The third one is the daily order sheet 19/08/2021 that I already annexed at 1021 at the page number 1021. Then there is a document that shows that the list of documents, which I did not actually get, that appeared by IO. There are 15 numbers of item he actually mentioned. There is the serial number 13 that letter dated 05/06/2022 from my side to MD, but this is not correct. There is no any document, neither they could produce that document. Letter dated 05/06/2020 and never submit any document to MD and I. Another is that serial number 11, where they mentioned that the letter dated 14/09/2020, that is from my side to CGMHR. They enclose some, they referred some document that I enclosed as a medical certificate. That point is very important because they subsequently also enclose those documents. I will go by the record subsequently. The next document is the daily order sheet 23/07/2021 that I already enclosed 1020 at page number 1020. The next is the IO addressed to me at 10/08/2021. That is the first daily order sheet of the inquiry proceeding that I already enclosed at 1368. Then the reply of the memorandum suggests that I already enclosed 486.
Then they again mentioned the memorandum of charges that I already enclosed at 503, and the reply of the memorandum of charges that I already enclosed at 508. So cause reply that I already enclosed at 478. So cause that I already enclosed at 436. CGM HR data dated 15/10/2020 that CGM HR issued to me that I already enclosed at 415 at page number. My leave application dated 21/09/2020 that I already enclosed 404 at page number. Then another letter that CGM HR addressed to me that on dated 17/09/2020, and that is I already enclosed at 407. That another document that they mentioned these documents are readily available with inquiry officer. That is the letter dated 14/09/2020. That was submitted from my side to CGM HR. That inquiry officer confirmed that he has this document. But the very first document, that was medical document 12/09/2020. That is the present medical document which the inquiry officer did not consider in his inquiry. But but departmental record shows that these documents are readily available and supplied to the inquiry officer. That is the vital document that the inquiry officer did not consider. Then another 5 numbers of medical certificate that I already enclosed from serial number 370 or 397 to 402. The next document is the CGM HR letter dated 10/09/2020 that I already enclosed at page number 396. The next one is my letter dated to MD 05/09/2020 that consists of 5 pages document that I already enclosed at 389 to 95. Then there is another document they provided there, that is the DGM HR letter email dated 03/09/2020 that I already enclosed at page 388. Then another document is 27/08/2020, that is the release order. Initially they mentioned it as a release note, but subsequently they mentioned it as a release order that I already enclosed at 358. Then next one is the daily order sheet 23/07/2021 that I already enclosed at 1020. Then next is the 19th.
No, is there any document?
No, yes, Lordship.
Which according to you, during the proceedings was not given to you, not shown to you,
Yes,
but relied upon. That
yes.
was the purpose for allowing you to go to the document.
No, Lordship, since there is no, I could not get the copy of those documents, so that I can actually try to convey this that these documents are already available. Other than at the serial number 25, there are some other correspondence also that enclose most of the document I already enclosed. That another document that serial number 25, that is 09/07/2021 that IO addressed to me. That document I actually somehow forget to address, but the document actually I found it very useful because in 9/07/2021 IO addressed to, while addressing to me, IO specifically mentioned that correspondence will be made over official in email as far as possible. But the Lordship, I submitted some documents that are very much important to the case in hand, but inquiry officer did not consider those documents also. I will submit those documents as an annexure to this honorable court after I submit the related facts. The last one is memorandum of charges that I already enclosed at 503. That then they submitted enclosed a document that is the CFD note. Actually, this note was already confirmed by inquiry officer as a CFD note.
What is a CFD note?
Company of functional director. Means other than the chairman of the NRL, all functional director approved the same. Actually, this document actually we already discussed in the last occasion. That document dated 12/03/2021 that was suppressed for a period of 5 months or so. This document, though inquiry officer randomly mentioned that this document was a CFD approval, but he did not provide any authenticate proof and any circulation proof that, but though inquiry officer mentioned that the document was circulated. Here also they could not provide any proof of authenticated details that that document was originally actually generated at 12/03/2021 and failed to provide the circulation proof also. Already proved that I already proved that this document was lately uploaded. Lordship, the most important thing is that inquiry officer already aware that I don't know how he get this information, but already aware that this document was as a CFD approval. But this document, in this document, it was only mentioned that the competent authority approved the same. But this document is very important because of CFD approval is confirmed by the departmental records. Now, Lordship, before going to the issue from the very beginning, I would like to, Lordship, bring to the kind notice of this Honorable Court the affidavit submitted by the respondent 4, 5, and 6. They took 11 months time to file an affidavit in opposition against my 250 pages pleading. Out of that, these 250 pages, only 90 pages pleading are fact of the
250, you have got 7 or 8 volumes. How can you say 250?
Initially, but repetition. I am talking about before that are written.
No, but somebody who will file your counter is expected to respond to all your allegations or documents. You have 7 or 8 volumes. How is it 250?
Initially, Lordship, my repetition pleadings are consists of 260 pages. Out of the 260 pages, 90 pages are only the fact of the cases. Out of they took 11 months time to submit a affidavit petition, but respondent 4, 5, and 6 submitted only 8 pages document. Kindly allow me to go through this 8 pages documents first. Kindly refer to the page number 1395 at serial number 2.
Which is the 1395 is where?
Lordship, the affidavit opposition submitted by the respondent number 4, 5, and 6.
Affidavit in opposition by respondent?
4, 5, and 6.
4, 5, and 6.
Only 8 pages document.
Yes.
Lordship, serial number 2 at page 1395. The respondent 456 asking that petitioner is to put the stated post thereof. After I submitted the all the proof, they failed to, Lordship, they submit respond against my submission, Lordship. And then, Lordship, the kindly refer to the serial number 4. The work culture of NRL does not leave any scope for an employee to think anything beyond work. The respondent did not have any time even to think causing harm or creating inconvenience to the petitioner. The next paragraph, the respondent seeks, with the help of senior official, the allegation of causing intentional inconvenience and harm to the petitioner by respondent 6 with the help of senior official are categorically denied. Petitioner could not adduce any proof of intention or any motive of or personal gain on the part of the respondent for causing harm to him as alleged in the instead paragraph. Then kindly refer to the next paragraph. Respond number 6, that it is stated that before joining the team of respond number 6, that is marketing department, the petitioner performance was below average. There is no any such kind of rating, Lordship, what below average. Neither he explained this kind of rating that below average is there. But I do not know why he used this kind of rating. Before joining marketing department, petitioner performance was below average, which is totally false, Lordship. His document at page number, Lordship, 1403 itself proved that he has submitted this false statement by contradicting his own document. Because, Lordship, I joined in Numaligarh Refinery in 2007. In 2006, from the next year, Lordship, the very first year of my service period, I was rated as very good performer. Then the next line, he himself annexed, he himself tabulated a document with the help of the enquiry officer who did not actually act as an enquiry officer. He just acted as a agent and representative of respondent 6. This 1403 was actually a Word document which was prepared by the inquiry officer. The next line is that the respondent 6 actively encouraged him and helped him to improve his rating to good and thereafter to very good. Lordship, under his while I was working under him, I was never rated as a good performer. For what he mentioned that after joining marketing department, I continuously rated as a very good performer. That is a totally a false and misleading statement. Help him to improve his good and thereafter very good. To facilitate his promotion as per NRL policy. Lordship, this is also again a false statement because NRL policy, I regularly get promotion as per NRL policy. Earlier also I got the promotion in the same manner. Why he tried to mislead this honorable court without having any document, without any supporting proof, just submitted a random 8 pages document with some arbitrary and random claim, Lordship. Then next line, Lordship. Accordingly, he got promotion while working under the team of respondent 6. Earlier also I got promotion in the same manner, Lordship. Conversely, his frequent absence, reluctant to accept assigned responsibilities, suggested a potential mismatch in the demanding work culture of NRL. Violation of conduct and condition of conduct, discipline and appellate rule. That is, I was a habitual violator. I was violating company CDA rule for a period of 13 years, and they were silent. And after 13 years, when I did not even follow the transfer order, also they repeatedly given some arbitrary opportunity to correct myself. But that kind of opportunity to correct myself never mentioned in any document. But kindly, I just try to mention this honorable court, appraise this honorable court, that he tried to create an impression against me, but at the same time they also entertain me. I submitted this fact because I need to counter this allegation from the very beginning of my service life.
Have you filed your reply to that?
Yes, Lordship. I already filed reply. Each and every point, every line I replied.
All right.
Violation of conduct, discipline, appellate rule of NRL pertaining to the management staff. This kind of actually false information actually circulated. Like I file a FIR, I have problem against everyone. I have made the complaint against everyone. That kind of information actually circulated and behind our back, Lordship. That is why people like us found difficult to work in a group, Lordship. So next paragraph is, before his posting in marketing department, Shri Obinash Bora was posted in commercial department.
his performance in that department was very poor, and same was reflected in PMS, Lordship. My performance was never poor, Lordship. I worked in a commercial department for a period of 6 months. Out of that 6 months, 3 months I was in medical leave, Lordship. Only around 123 days, I cleared 29 numbers of tender from taking approval to awarding contract, and another 15 numbers of contract closing proposal. They could not prove that prior to me, any official could process such kind of work within a short period of time. They could not prove that these are the ordinary performance. I performed while I was taking medical treatment also. And Lordship, while I transferred from commercial department to Gauhati marketing, my immediate reporting gave me an offer that I will give you that kind of facility, that kind of facility, that kind of facility. I already talked with my HOD, and he, Lordship, warned me. He not only wanted to keep me with him. He gave me lots of offer, and he told me that you work with him, work with us, I will give you this kind of facility. And he warned me, Lordship, that you will going to face a very bad consequences. Actually, when he called me, that time was little bit awkward, and he told me that some person was along with him. That is why I recorded everything that I already available with my phone. That he in 2017 he actually warned me that you are going to face a very bad consequences. That are already available in my mobile. If required, I will provide in this honorable court along with the certificate as per section 63 subsection 4 of Bharatiya Saksha Adhiniyam. The second point is he also posted an NRMT. There also his performance was poor. He has received 6 average which was poor. Lordship, his document itself proved that he submitted a false statement, because his document never reflect that I have ever been rated as a poor performance. And in NRMT, I have continuously given very good and good performance. When respondent 4, Mr. Apurva Pratasaji and joint Numuligar, when respondent 4 was my sectional head, then only I received a poor rating for a period of 3 years. Even though that 3 years, my performance was extraordinary. I have performed the highest level in the history of Numuligar refinery. I will give all the data and facts, but while they claiming my performance as a fair or poor rating, they could not provide any document. PMS rating document are readily available with them, but they are submitting a fabricated document with the help of the inquiry officer, who was acted as a agent and a representative of respondent 6, Lordship. And Lordship, his document itself proved that he has submitted a false and misleading statement in this honorable court. The next point is the petitioner performance in the marketing department was also poor. But
we are not going into this. We are not examining your service records or the markings in your service records. You're essentially challenging the proceedings.
Lordship,
Right. So therefore, we are not sitting here as a departmental authority. We are not sitting here as an appellate authority. We are only to see whether in the contours of law laid down by Supreme Court, High Court, whether the law, the parameters laid down has been followed by the respondent authority in proceeding with the inquiry, imposition of punishment, and the punishment which is imposed. That's all.
Lordship,
Now, what gradings you received, how good you were, are not issues before this court. We are not examining your ACR records or APAR records. This is not the issue here.
Lordship,
So your ground is that this particular person has created a wrong impression and has tried to malign you. That is what you're saying.
With respect to the imposed penalty, the Honorable Supreme Court in operative precedent that 30 long period of service is also required to be considered.
No, that is what we are saying. This is to be considered for what purpose? Long periods to be considered for what?
Discipline as well as performance of the employee that are also
Therefore,
required to be considered.
Exactly, we'll examine that aspect.
But they are submitting. I need not to submit this kind of. I just give a very starting of my
No,
petition,
you are right. We are not discounting you on that. What we are saying is that you are essentially, you are challenging the process, disciplinary process undertaken. Whether the procedure has been followed, whether you have been permitted to be to examine the witnesses, cross-examine the witnesses, whether documents have been given to you, whether you're given an opportunity to be heard. These are the areas that you should address.
Yes, Lordship, I will address this honorable court, but before actually going to
No, first you address that. Then, if required, we'll permit you to address on other supplementary points. But this is the core issue.
Yes, Lordship.
Because you see, we are not here. We don't have the time to listen to you alone. There are other matters. There are other lawyers waiting to be heard in this matter.
Yes, Lordship,
So you have to be very precise.
Yes, Lordship, I will try my best to precise everything. But Lordship, I also claim that respondent 4, who claimed himself, who was the director technical at that time, and who claimed himself as the MD in charge. But departmental record, though this honorable court mentioned that they need to submit the appellate proceeding, they failed to submit that the respondent for Mr. Bhaskar Jyoti Phukon has the authority to act as a MD in charge. But he was, as per the information available in Facebook, that was published in the Facebook of Numoliga Refinery, I only received that he was given an additional in charge. Additional duty, but he was never give him any kind of information. I did not receive that he was given the MD in charge. He was thus recommended for promotion. Honorable Supreme Court repeatedly emphasizing different orders that a person, when recommendation is given, that person does not cannot take the authority of his cannot take the rank and position of the superior authority. But this honorable court in the last order dated to 28/01/2026 ordered that the appellate proceeding is required to be summoned. That they still try to suppress. Against this there are lots of documents they try to suppress. Against this information and details and particulars and facts, I already in my interlocutory application, I prayed to this honorable court to take an adverse interference for all those issues that they try to suppress. And that is why, Lordship, another issue is that since I claiming that respondent number 4 and respondent number 6, along with one person, Mr. Apupa Kumar Bhattacharjee, repeatedly try to create inconvenience from 2008, Lordship. There are departmental records, there are official communication that they try to create inconvenience. In last occasion, the amicus query mentioned that I made complaints against everyone. That is not correct, Lordship. This is totally misleading. The amicus query mentioned that I even filed.
So you'll not address to the amicus curiae. Amicus curiae we have appointed. We have appointed. So we have appointed to enable to assess the court. Right. So you may say that these statements or submissions made are, you may refer to relevant pages. But don't make accusations against the amicus curiae. Will not even permit you to be heard before this court. Yes.
Then kindly allow me to actually the issue related to the medical leaves and
whatever you want to argue, we are giving you time.
Yes.
Another 10 minutes, then we'll hear the other side.
10 minutes, Lordship.
10 minutes. We can't give you the entire day.
No, at least give me at least 1 hour, Lordship. Otherwise, it is not possible for me because.
Hey, 1 hour, you are giving us the entire history. We don't need your history.
No, sir, there is a systematic manipulation, Lordship.
No, systematic manipulation also, we are not going into it. We are not exercising this jurisdiction to examine how you are manipulated. We are examining your challenge made to the proceedings undertaken. That's all.
Then, Lordship, kindly allow me to short brief of from what is happening with me from 2007 to 2000, Lordship.
No, you address us on why you are challenging the departmental proceedings,
yes,
and why the conclusions arrived at are bad, and consequently why the order passed by the order of what is that? Dismissal, removal, removal. Removal will disentitle him from pension, is it? There is no pension. Otherwise also. So these are the areas we'll hear.
My issue was arose after a transfer order that transfer me from Gauhati to Numaligarh. At that time there is some medical issue. I actually addressed the issue. Because I faced some medical inconvenience at Numaligarh also earlier. That is why I placed the representation along with some details also. It is not that I submit a complaint against the doctors at Numaligarh. They even emphasize.
You're going back to these allegations. We are not interested in that. Against who you have filed application, who considers you what. You tell us that there is a departmental proceeding. You had received a show cause.
These are the related lots
No,
because
no,
the medical.
related, you leave it to us, we'll examine it. But you tell us that there is a show cause notice given to you, you have to give a reply. Then the proceedings have started. According to the amicus, or from what we could understand, you did not participate in the inquiry. Now, why you did not participate and how it was inconvenient for you to participate is what you have to tell us. If you want time to
No, Lordship,
recapitulate on all this,
Lordship,
tell us.
Since this honorable court already mentioned that this honorable court look into other issue, I only need to address the related to the department.
Because that is the law. We are not an appellate authority over the appellate authority of the corporation. We are only to examine whether you have been prejudiced in the entire process.
Yes, Lordship, because transfer order was issued from Gauhati to Numaligarh.
You are not challenging. Are you challenging the transfer order?
The transfer order was actually that at that time that there is a misrepresentation that I was allowed to work against the transfer order. At that time, I cannot challenge the transfer order because and then
Is the transfer order challenged before this court in any proceedings by you?
the Lordship, the document issued on the behalf of the transfer order, I challenge all those documents.
We are asking you a very simple question for which
transfer order was
not challenged. Not challenged.
Did not challenge because there is no any.
Need not or could not is not the answer. The question put to you is the transfer order challenged by you.
No,
it is not challenged.
At that time, I did not challenge because there is a misrepresentation. There is a suppression of material.
Subsequently, did you challenge?
Yes, Lordship. In the
writ petition, is there a prayer for setting aside?
In an interlocutory application, I mentioned that the transfer order did not challenge because of there is a misrepresentation, there is a suppression of material fact. They did not put any allegation that only after only in the affidavit of opposition they put some allegation that I violate the transfer order, but not joining at the Numaligarh from the next day of the transfer order issue or from after immediately after 60 days. But during that time they actually act as that they were allowed to allowed me to work against the transfer order. That is why I actually try to actually apprise this honorable court how the issue are related to the transfer order. If those issues are very much related, Lordship, otherwise it is very difficult
for you it may be related, but for us it is not, because we are examining the challenge made to the proceedings.
I already challenged, Lordship, transfer subsequent activity after the transfer order, because initially I could not submit because there is a misrepresentation, there is a suppression of material fact. But in the interlocutory application, I mentioned it, Lordship.
All right, then you do one thing. Let us hear the other side. You will again get an opportunity to reply after what they say.
No, Lordship, allow me to actually submit the facts. Then only they.
You have submitted your facts.
No.
We have understood your facts.
Lordship, first at least allow me to give the hints of some issue that they need to address. Otherwise, they did not address in the affidavit of opposition also. Now
so
also.
Tell us what areas you want to address.
Yes, Lordship. Since I could not actually submit what is happening with me before the transfer order.
We are not concerned with that.
Because the transfer order was issued on 0506/2020. I was transferred from Guwahati to Numaligarh. Prior to that, I was transferred from Numaligarh to Guwahati only because of medical reason. They themselves in the affidavit opposition confirmed that I was transferred from Numaligarh to Guwahati on medical reason. And they also mentioned that on the basis of my representation, that I detailed submission about the inconvenience I face, negligence, wrong treatment I have faced in Numaligarh. And before coming to the Guwahati, I was transferred from Numaligarh to Guwahati on 31st/01/2017. That transfer was not an annual practice. They mentioned that 2020's transfer order is an annual practice, but 2017 was not an annual practice.
That we can examine only if you challenge the transfer order, that it is not authorized, violative of the rule.
At that time, Lordship, I did not.
So you did not
There is a
challenge.
misrepresentation.
That is what we are trying to, we are with you. We are trying to make you understand that since you did not challenge the transfer order, the reasons why the transfer order was issued or should not have been issued is not an issue that we are required to be concerned with. We have to look into the proceedings which are initiated, which you have challenged, leading to your dismissal. That is the only area that we are looking into it.
Kindly at least allow me to what is happening after the transfer order. At least the sequence. No, because I actually challenge all the document, Lordship, after the transfer order. I challenge the release order, Lordship. I challenge the show cause notice. I challenge the memorandum of service. At least allow me to submit the facts related to the release order.
That facts are already here. You have got enough documents and the list of dates and everything is here. We can look into that. You have to tell us how this has vitiated the proceedings.
Lordship, as per the transfer order, Lordship, can you refer to the page number? Uh, 345. Lordship. That's volume 1, volume 2.
Yes.
Lordship, in the second paragraph, it is mentioned that however, in case of transfer involving the change of location, the time allowed shall be 60 days as per prevailing. For interstate international transfer, separate advice for such movement will be given to the respective staff and they shall move within 60 days of such intimation. In the last paragraph, Lordship, it is mentioned that in the last line, all officers on transfer need to submit a copy of handing over, taking over note to HR along with their joining report. Lordship, kindly refer to their submission. Transfer order, Lordship, refer to the submission at 808. Page 808, Lordship, their statement affidavit in opposition 808.
808. What volume is that?
Affidavit in opposition.
Yes, 808.
In case of transfer, is a incidental of service, and petitioner is being an employee of NRL is bound to comply with the order of the transfer and work at whatever place is posted in exigency of service. The petitioner has not allowed alleged any malafide in such transfer, and moreover, the petitioner never challenged such transfer. At that time, Lordship, they allowed me to work against the transfer order. So how can I challenge the transfer orders? How can I mention that the transfer order is malafide? As per the transfer order stipulated clause, then transfer officer is required to join at the new place in case of vocational transfer within a period of 60 days. But within a period of 60 days, they did not release me. They mention in their affidavit in opposition that management allowed them to work, allowed me to work till release. But they did not mention any specific that management means MDNR. They did not mention any document. They did not submit any document also. That after the violation of transfer order, whether it was violated by me or whether violated by them, MDNRL allowed them to allowed them to work me at my present place also. That they could not submit any documents. And even though they could produce any document, any approval that MDNRL allowed them to work beyond 60 days, then this will help me to prove the malafide. Because as per existing rule that already mentioned in the transfer order, as per existing rule, they need to release me before 60 days. They need to give instruction.
So according to you, although the transfer order was issued, within the stipulated time, there was no release order.
There is no release, but they try to manipulate the issue that
you defied.
I violated the transfer order. They were sitting idle until and waiting for an option. They mentioned that we did not have any option to allow him to continue, but they got an option after 82 days to release me. And Lordship, release and instruction for handover and takeover is a prevailing practice, and it is a existing process. It is widely available in companies made company system. There are lots of documents that I will submit in this honorable court, but kindly allow them to submit that management allowed them to continue my duty after a period of 60 days, even though they mentioned that I have violated the transfer order. They mentioned that they have given me an opportunity to correct myself, but that is more serious issue. A official who did not follow a transfer order for a period of 60 days. After 60 days also, I violated the transfer order. They were sitting idle, Lordship. They even could not give me any instruction to hand over duty also. They try to create an issue against me by handing over, which related to the handover of the duty. There are some communication. There are some communication that I am going to produce this honorable court already annexed along with my submission also. That is the release order is required. That I will prove. There are lots of documents in company's mail as well as system. There are lots of documents in company's mail that officers are required to instructed for taking handover or takeover duty. There are lots of documents that HOD of the department required to confirm that transfer officer is or before releasing his position, hand over his duty. There are official circular also, but they try to manipulate that MDNR. That is why I actually try to go by all the facts. Otherwise, they could able to mislead this honorable.
They have not even started. Why do you say they will mislead?
Already there is a.
They have not even urged. You have not allowed them to urge.
No, Lordship.
We are giving you all the time.
No, sir. After my submission only, they will not going to address this issue.
Right.
After that.
Okay.
That is why, because after, if I submit the issue, then they will going to address it. Then only I get an opportunity to defend myself.
All right.
But the main issue is that the transfer order, before issuing the transfer order, there is a lots of issue happening with in marketing department. The respondent 6 and another officer repeatedly tried to target me. That is why I submitted a complaint that I already applied this honorable court on 27th of 05/2020. That immediately after that complaint, a transfer order was issued on 05/06/2020. Subsequently, I also submitted a whistleblower policy. I submitted complaint as part of whistleblower policy. I get a response for other whistleblower policy, but I did not get any response for that whistleblower complaint. They immediately transferred me to Numaligarh. Though prior to that, I was all in on transfer from Numaligarh due to some medical issues that was happening in Numaligarh. But they mentioned that this is a regular practice, but they could not address that earlier transfer was not a regular practice. When they mentioned that the transfer order was exigency in operation, but they failed to address that why they delay to comply with the transfer order for a period of 82 days. Why they in place of 60 days? They even mentioned that I need to proceed to join the new location even after the next day of issuing the transfer order. But they could not address to this honorable board in exigency of service also why they waited for a period of 82 days. Why they could not issue the release communication even on the very next day or even on the 60 days, Lordship. And Lordship, this exigency of operational exigency, they did never mention in their any document, Lordship. They never mentioned in any communication of official communication. Kindly allow them to address first that MDNR allow them to after violation of transfer order, MDNR allowed me to continue duty until unless the respondent 6 as per his desire and will until unless respondent 6 release me as per his desire and will, so that I cannot take a leave without taking prior permission, or so that they can send me to Numaligarh to do a medical examination as they done earlier in 2016 to suppress me and with the help of doctor they actually try to manipulate and submitted misleading information to the top management so that I can be the whole issue can be manipulated, Lordship. After the transfer order, I submit a application to MDNR, which I annex at 347. They mentioned that they respond to this document, but they fail to submit that. They mention in their written statement at page 8018, then another 814, 813, 816, and 822. They did different statement that this representation that I submitted against the transfer order, they responded, but they could not submit that in which document they responded this representation. Then, Lordship, respondent 6 before 60 days. Before 60 days, respondent 6 himself called me over phone. I already submitted the details call recording to the chairman of Numaligarh Refinery along with my review petition. But respondent 6 in his affidavit in opposition mentioned that he never called me or contacted me over phone which related to the transfer order. But Lordship, kindly refer to the page 353 and 355. But in 353, that actually I was supposed to join at Numaligarh with respect to the transfer order time period of 60 days, that I need to join at Numaligarh 03/08/2022. That was confirmed by respondent in their affidavit of opposition. But Lordship, prior to that, without releasing me, without asking me to hand over duty, the respondent 6 called me over phone on 31st of July 2020, and he asked me to submit an application against the transfer order. That I submitted after 03/08/2020.
When did you submit your representation?
04/08/2020. That was addressed, Lordship. But they mentioned that I
Which date?
04/08/2020.
2020.
But they mentioned that I need to join before 03/08. But after 04/08, after 03/08, I submit an application against the transfer order. They address it. In this application, I mentioned right to GM Marketing, Numoligarh Refinery Limited. That is the respondent number 6. That dear sir, I am writing this application with
Mr. Counsel, don't go through all these pages. We have given you enough time. We are putting you to final notice. If you want to address something, you address on the legal issues.
But-
Factual issues are already there. We know about that.
these are the, because he himself.
So you are alleging malice against.
Yes, okay. He himself asked me to submit an application against the transfer order. Now they can claim that I violated the transfer order. That was I specifically mentioned in my letter dated 3/53 that I am writing this application with effects to a recent advice. And I mentioned to the MD and Lordship at page 389, Lordship.
Who's for the respondent 6?
Respondent himself fabricated an issue, and he himself became a judge, Lordship.
We'll have to hear him, na? Anything more?
Lordship, there are lots of issues, Lordship. Otherwise, it will be great miscarriage of justice, Lordship, because the learned
You are not allowing us to go ahead with the delivery of justice.
Lordship,
You are giving us all these facts when we are repeatedly putting you to notice that our contours of examination of this matter is only with regard to the
these are the issues.
disciplinary
These are the
issue.
issues very
You
much.
may like to urge it, but we are not interested to deal with these issues. We are not. There are judgments. We'll give you the citations. Please read and come back. This law declared by the Supreme Court is binding on us. We can't go beyond that.
They impose allegation against me. I need
You
to
have other
defend-
forums. You have access to legal advice if you want.
No, I need to defend, Lordship. Otherwise,
You need to defend. You first need to say that how this order of how the disciplinary proceeding is bad. You are building up a case of malice against this person. All right, we'll have to hear him on that. Besides that, what else do you have?
to establish the malice, I have to submit that there are sufficient proof, Lordship, because he himself instructed me to submit an application. Then after that,
Where is the malice there?
no,
He's an officer superior. If you have gone to meet him, if he gives you a suggestion that all right, you file a representation. Where is the malice?
he imposed an allegation that I violated the transfer order. But before the transfer order was with respect to the transfer
We
order.
have accepted, we have heard your submissions that you ought to have been released within 60 days or you are not done 82 days after that you are released. We have taken note of that.
Lordship, in MD to the letter dated MD also that they mentioned that they have actually responded to this application, but they could not provide any proof that this application was also responded. 05/09/2020. That
What materials do you have to say that the respondent 6 has maliciously initiated this proceeding?
Yes, Lordship, that is to address this issue of that respondent 6 maliciously initiate the proceeding. I need to address this issue, Lordship.
What issue?
Because Lordship, the transfer they issue a so cause notice.
You can't address the court for all these documents to say that unless these documents are read out to the court, you have not been given a permission to, or you have not been permitted to raise a or develop the case of malice. You give us in a nutshell that yes, these documents clearly establish
Yes, Lordship, that
the malice against you.
yes, Lordship. Thus,
After that, if required, we'll examine other
Yes, sir.
documents.
so so cause was issued after my
Yet we have heard.
the-
Here there is a transfer order. According to you, you are not released. Therefore, you could not hand over charge. You could not go. the period given is 60 days, but they released you after 82 days and alleging that you had violated the transfer order. Essentially, that is your case.
So there are other issues, Lordship, because the transfer order was violated by him. Then subsequently, I intimated a leave against the leave intimation. Though initially they mentioned that I need to take prior permission for leave. In the so cause notice, I replied to the so cause notice. I mentioned that I could not take the prior permission of leave. Then at that time, if prior permission is compulsory required, they need to issue a voluntary abandon of company service order of voluntary abandon of company service to me, but they did not issue because they consider that prior permission cannot be taken at that time because by considering that unavoidable circumstances, they did not impose any allegation against me with respect to the prior permission. Why they did not impose? Because transfer order was violated by them. Because after violation of the transfer order, my leave application cannot be addressed by any superior authority. Because before addressing my leave application, superior authority first need to address that transfer. Why the officer did not join at the new place as per the transfer order. Then if they made an allegation that
that is your case, you should have brought up before the departmental authorities. You did not appear.
I appeared, Lordship. They just try to legitimate a predetermined penalty, Lordship. The inquiry officer did a preconceived bias, Lordship.
Where is the reply you submitted before the?
Kindly allow me to at least. These are the very vital documents. Otherwise, there will be their miscase of justice because they are submitting lots of manipulated allegations against.
You show us the reply to the show cause. Page number.
Kindly. Can I refer to the page number? I will go to the reply, Lordship. Before going to the reply, kindly allow me to show the so cause notice. That I enclose at 436.
436. You don't say the page number alone. You tell us the volume also.
Volume number, volume 2. Lordship.
Yes, volume 2. 436.
Lordship, the very first line. This is reference to the office order personnel 16 confidential annexure 2 dated 27 August 2020. There is no any office order on dated 27 August 2020. They just to suppress the violation of the transfer order, they issued this so cause notice. Only a one page so cause notice after a period of 192 days. But very first line of the so cause notice, they wrongly mentioned just to suppress the issues, just to divert the issue of the violation of the transfer order. Because the transfer order was violated by respondent 6 and with due authority of HR department. Lordship,
where is the reply?
Lordship, the release order.
Where is the reply to the show cause?
Yes,
Where is the reply to the show cause?
478. The release order required to be Lordship, release order required to be marked to the new location in charge, but he did not mark the release order to the new location in charge. He marked to the Mr. Rajiv Bhattacharya. That is a pre-plan, Lordship. They mentioned that repeated communication.
After this reply, is there any other reply you filed?
No, Lordship.
This is the only reply?
Yes, Lordship.
What is this reply at page 508?
is a memorandum of service. Reply against the memorandum of service.
And what is this reply? 478?
478, Lordship, reply to the show cause notice.
Show cause notice. Show cause notice, you have given a reply. No. Show cause notice dated 1912.
02/12/2020, but it was actually sent to me on 12/12/2020. They use a backdated show cause notice.
212. 212, you reply on 28/12.
Yes, Lordship. That I already mentioned in my reply. at 478 Lordship.
Yes.
Prior to that, I made a communication to CGM HR with respect to the so-called notice, where I mentioned that all the related document, all the related communication that I made with respect to the transfer order, I request him to submit, to forward all the related document to the appropriate authority, who will going to take the decision of the so-called. Then, since I have mentioned this, submit this application to CGM HR, then that is why they could not actually issue a voluntary abandon of company service by misleading the appropriate authority. That is why they completely shift their standards. The very first line in the so-called notice, I mentioned that this letter received by me on 19/12/2020 at my permanent address and on 20th at my present address. The so-called letter dated remand was sent on 12/12/2020. They use a backdated so-called notice. I do not know why they use by using a backdated notice.
Did you raise all these issues in the reply? That there is a malice against you?
Not that, because they did not impose any allegation against me with respect to the transfer order violation. They did not mention that I could not take leave after the transfer order. They did not mention that their communication are compulsory to join duty. After their communication, I cannot take leave. Lordship. There are no any allegation. Then how can I, Lordship, place?
When these allegations were raised?
That allegation are raised in this honorable court only. They even, Lordship, forwarded my application for consideration. They mentioned that you need to join at Numuligar as per the release order, but they never mentioned that with respect to their release order, I cannot take leave. Lordship.
Okay.
We
will like to hear the respondents now.
There is lots.
No, you take your seat. We'll hear the respondents. We'll give you an opportunity later.
After their submission, if I submit issue, they will not going to respond. Otherwise, how can
It is up to the court. Take your seat. Yes. Next Tuesday, yes. What do you want it next Tuesday?
Let it be next Tuesday. Let us start afresh, man.
Why?
I can reply, man. Difficult.
No, sir, kindly.
So if you want to start afresh, you will start afresh. We don't want that. We want you.
Not a single CTO rule was proposed.
Are you averse to lighter movements? Why do you dislike? Smile is good for health. Sit down. Take a
Last
smile.
5 years, I am suffering. Lordship.
I know, but is it because of the court? And entirely, no. Part of it, maybe yes. The hearings are taking place. Your suffering is self-inflicted because look at the volume of papers you have placed.
Because, Lordship, they are, for one issue, they submit lots of.
Now you take your seat. Take your seat. Take your seat. If you want some water, we can provide you. Sit down. Yes, Mr. Deka.
Yes, ma'am.
According to you, the transfer order, according to him, the transfer order is issued. He is required to be released. You don't release him. You release him after 82 days. And then you turn around and say that he has violated the transfer order.
And the transfer order itself says that he should join. We should not release. Time is, please.
Unless you say that under the rules, there is no provision for release or unilateral.
The question of release has come in this case because of his refusal to join, Malad. Normally,
no. Is there anything under the rules?
There is
under
no such
notification?
transfer rules, Malad. There is no such transfer rules. The transfer order, Lordship, finds it 345. Volume.
You have seen the transfer.
Yes. It says, Malad.
There are transfer orders to other personnel, including the writ petition.
Yes. So 60 days is given to him. He does not join. He says that he files a representation in May, Malad. That is not correct, Malad. First representation is of June 18/6. In 18/6, 347,
he files the first representation.
Hmm.
I have prepared a list of dates, my lord, and a written submissions, my lord.
Yes.
But that I may be required to modify, my lord.
Modify, you don't add to the volume.
No,
Just
no,
give us a 2-page.
it is not 2 pages, around
all
7,
right.
8 pages, my lord.
7, 8, why? You just give us a list of the sequence of the
A sequence
documents
of
with
events is 2 pages, 2, 3 pages.
sequence of the communications along with
Yes.
the relevant page number.
That I have it, that I have it.
That you give us, or that
Yes.
Mr. Das can also give us if you think it is necessary. And then
Leonard brother has prepared one for your lordship.
you prepare and bring it on Tuesday.
I have something,
You have it.
I have it.
May I please, Lordship? Lordship, this honorable court repeatedly gave them an opportunity for last 4-6 months. They are not submitting. This case is unnecessary delayed, Lordship. I am harassing, Lordship. There is a urgency in this matter, Lordship.
No. There is an urgency, but if you want us to quickly pass an order, we'll give you the liberty to draft the order, give it to us, we'll sign it.
No, Lordship.
No.
They were.
Take your seat. Take your seat. Don't overindulge yourself. Yes.
Page 18, my lord, list of
18. Yes.
First, the events start on 5/6, my lord. He is transferred. Lordship has seen the order. Then at page 347 is this first representation, 18/6. He cites his health reasons, my lord. I'm just giving a gist. Nothing, no malice, nothing, my lord. No allegation is brought out, an allegation against any superiors. Only his health problems. Then, my lord, 4/8, he files a second representation. That is a 353.
Yes. Any reply to his representations?
There is replies come subsequently, my lord. And 27/8, that is at page 358, he is ultimately released, my lord. He did not join. Ultimately, we had to release him, my lord. He was released with effect from 27/8. In spite of that, he does not join, my lord. He files another representation on 1st of September. That your lordship finds a 385. Then on 388, we ask him to join at Numaligarh. May I just take your lordship to that minute? Small order. 388, volume 2. It's an email communication, my lord.
388.
388.
Yes.
Yes. It is observed that you have not reported in your place of posting at NRMT even after your release from marketing office date on so and so. You are hereby advised to join at NRMT Numaligarh and report to CM, Chief Manager, on or before 7th September. Please note, from 7th September to the 2020, your attendance will be mapped to NRMT refinery location. Now, in spite of that, man, he does not join, my lord. Then again on 5/9, he submits a representation. This is on 3rd September. 5/9, he submits another representation. Then lordship turns to page 396, my lord. This is in reference to your letter dated 5/9 addressed to the managing director on the subject. Lordship has got it. On the subject, prayer for continuation of duty in the same job and in the same location. We have gone through the content of your letter and would like to bring the following to your notice. NRL is a single refinery company with lean manpower, and transfers of officers into its refinery located at Numaligarh is a routine procedure. The letter of appointment issued to you, by which duly acknowledged by you, clearly states that your services are liable to be transferred anywhere in India, so and so. Number 3, my lord. A hospital with 24 hours medical facility run by Vivekananda Kendra is available inside the township to take care of medical need of employees and their dependents. There is also provision for referral of patients to other hospitals. And number 4 is most important. Your job at NRMT is basically a desk job. The reasons given by you for withholding or transfer do not qualify as a case to be considered on compassionate ground. Taking the above factors into consideration, we regret to inform you that your request for cancellation of the office order cannot be acceded to. You are advised to take a sense of responsibility should prevail upon you, and you will join your place of posting immediately in line with the office order that is filed. Then he does not stop at that matter. 14.9, again a subsequent representation, next page. Then on 17.9, we write to him at page 403. I'm not taking your lordship.
19.4.
No, my lord. 14.9.
14.9.
He writes, lordship is following the list of dates, my lord.
Yes, 14.9. There is no 14.9.
14.9 is there, my lord. Just immediately after 10.9 at the top.
Huh?
14th of September.
14,
Page 19.
Page 19.
At the top is 10.9, which I have just now read out.
Yes, yes, 14.9.
Yes. 14.9 of second, another representation. Then 17.9, we again write to him that we are reiterating what we had stated on 10.9. Then again on 21.9, a further representation. Page 404. Then on 415, my lord, 15.10.
All this without joining.
Without joining. Finally, on 15.10, we say that we will consider everything. We'll write us something to. It has been forwarded to the HOD, but please join as per the letter dated 27.8.
Then when does he join?
He does not join.
So he does not.
He
join.
does not. Then ultimately on 2/12, the show cause notice is issued. He replies to the show cause notice. 2 replies again, my lord. I'm just reading out the list of days. On 24/12 is the first reply. Then again 28/12 another reply. Then 12/3 is the office order by which the 5 officers are authorized to act as the discipline authority. And 19/3 is the memorandum of charges. Now he has not made any argument that any prejudice has been caused to him, or what has not demonstrated as to what prejudice has been caused to him.
That he is trying to demonstrate by saying that there is a malicious, some malice has been resorted to.
Malice in issuance of the order of transfer, or malice in the initiation of the disciplinary process.
Initiation.
Yes.
Initiation, according to him, there is this transfer itself is a malicious order. Is that correct?
Yes, lordship, but there is a application. Yes,
the answer is yes or no.
Yes, there is.
Yes, then take your seat.
There is a
Yes.
application which the Learned
Sit down, sit down.
makes, lordship.
Sit down.
There are
So
applications.
his allegation is the transfer itself
Yes.
is malice
So my answer
by
to that,
respondent 6
My-
or other officers.
my answer is that, madam, that is
And
not
you have not taken into account the allegations which you have raised vis-a-vis the respondent 6.
my answer to that is that, madam, the transfer order is not under challenge before this honorable court. Had he challenged it at the right appropriate point of time, that's a different matter. And in the representations, he does not say it is actuated by malice. In the first representation dated 18/6, he cites his health reasons, madam, nothing else. Now, this is all subsequently developed. He does not want to go to Numaligarh. So he has made allegations against the doctors of Vivekananda Kendra. He has made allegations against his discipline authority, now against the managing director. He also questions the authority of the managing director, whether he was allowed to hold charge as managing director. Now, if a charge sheet is issued to an employee, and then the disciplinary authority has to prove that he is the discipline authority, my lord, and it will be very difficult to maintain discipline, my lord, with utmost respect.
No, but that cannot stop
He can challenge it, my lord.
citizens to come and say
No,
that there is no
definitely not.
authority.
Definitely, of course not, madam. But without participating, if he says that show me your authority as discipline authority, that will be very difficult, madam. And then the 12/3 order was shown to him. He says, no, I want confirmation in writing.
What is 12.3?
12/3 is that order authorizing the respondent number 6 to act as a discipline authority, as the functional head.
What is the meaning of functional head?
It is basically the head of the department, that particular branch. My lord.
So he says it is only temporary appointments, temporary charges.
My lord, the functional heads may change, my lord. Someone who is heading the HR department may be transferred tomorrow to the marketing department. My lord. Then he will be the head of the marketing department. It's a small refinery, a small organization. One office at Numaligarh, one at Gauhati, one at Silchar marketing terminal. So the officers keep on rotating. The person who is the GM or chief general manager of HR may tomorrow be the chief general manager of commercial. Man. Then
No,
he will be the functional head of that department.
His contention, if I remember correctly, is that this person has been given a charge to hold this functional head. He does not,
Let us come to the order.
fall into the rank.
Says that he put the rank of DGM.
His rank holds the rank of
I'm sorry,
DGM.
order.
May I please submit? Lordship, this document never authorized him as a disciplinary authority. Never mentioned. And this is a CFDI approval that cannot override company CDR rule. That was approved by board. There are lots of issues, Lordship, that the learned senior counsel missed, Lordship, that if this honorable court allow me to submit those issues.
That is why I said, my lord, it is better if he concludes. My lord.
Oh, we'll give him an opportunity to conclude.
Definitely he'll have.
Where is that order?
556, volume 3.
556.
In my list of dates, it is at page 20.
Yes.
Based on approval of the competent authority, the following 5 officers are hereby authorized to exercise the rights of functional heads in matters pertaining to disciplinary action as per CDA rules. Person at serial number 4. He is the general manager marketing.
Now, what does the CDA rule say?
CDA rules. CDA rules at page 437. Volume 2. The CDA rules was amended subsequently. I'll have to read these. The disciplinary authorities, Lordship will find it at page 472.
Where is the CDA rule?
4.
That is the conduct rules.
Yes.
Okay.
Conduct discipline refer 437. Lordship will come at 472. That is the subsequent amendment.
$472.
Yes. We are concerned with serial number 1, my lord, because he belongs to job C, I think. All penalties other than dismissal, it is the functional head of the department. Incumbent should not be below the rank of GM.
All penalties other than dismissal.
Yes.
Now, who has passed the order of dismissal is equal
Not
to removal?
dismissal. Not dismissal is not equal to removal. Dismissal is defined separately.
What is the difference?
Dismissal, he is ineligible for future employment.
Removal is?
Removal, he is eligible to apply for a job in any other PSU. But if it
Not
is
NRL.
Not NRL.
Where does it say?
It does not say so, my lord, but it will be. No, removal from service which shall not be a disqualification for future employment. So it will mean for NRL also, my lord.
But you don't want to keep it in the future.
This is the conduct, my lord. Lordship sees. Had he joined, my lord, in fact, even after that 27/8 also, my lord, had he joined within a reasonable period, my lord, I don't think action would have been taken. But he has defied everything. The penalties are at page 454. So therefore, reading 472, my lord, the functional head of the department is the disciplinary authority. And by that letter of the order of 12.3, which is again, my lord, not under challenge,
Yes.
here in this case, the functional director was the director technical, and he was at that point in time holding charge of MD. So the ultimately the reviewing authority was the chairman in this case. So charge sheet has been already read out to your lordships. I will not trouble your lordships again, my lord. Then he submits 2 replies. Then the disciplinary proceedings start, my lord. Lordship will kindly turn to page 550. That is third volume, second volume, last page.
550.
550. This is the record. Just give me one. This is the first order of the inquiry officer. Earlier notices were issued. Yes, this is the first order of the inquiry officer. 23/7. Lordship is ready, I think.
Yes. This is what the first order.
Yes. Now, Lordship will kindly see point number 3. There is, it says the charged officer then stated that without receiving any reply to his above mentioned letters dated so and so and so and so, he will not participate in the inquiry or sign any documents. Now, those letters are at page 508 and 5486.
Yes.
508.
That's all right. We are not concerned.
He is
with the
questioning. He is questioning the authority of the disciplinary authority. He is not the disciplinary. Then he goes without signing.
Now, this was addressed to whom? The disciplinary authority.
The letter.
Huh?
Yes. I'm just cross checking.
508.
508.
You tell us the page numbers. 194 is?
508.
194 is page 508.
Just I'd like to draw your lordship's
And
attention
then
to
4521
is 486. Just for a moment, if your lordship takes up 508. He is saying that Subrata Das is not the GM marketing. Lordship, will kindly look at the top to whom it is addressed.
This is addressed because he is holding the post, but according to him, he is not a GM. He's not saying that Subrata Das is not the GM.
He is saying, Manu.
No. He's saying Subrata Das, although he is shown to be a GM, he is actually an AGM. He's not DGM. He is not in the rank of GM. That is his. That is his
all
claim.
the posts, and I'll show that document, Manu. All the posts were upgraded, Manu.
This is what he's saying.
Yes.
That he is actually a DGM, but because of the renomenclature or upgradation,
now
he has become a GM.
The posts have been renamed. Let us for a moment assume There is a change in the nomenclature.
Hmm.
My lord, corresponding CDA rules are not amended, my lord.
So-
Had it been the intent
so-
of the management, that
So
no,
his argument is,
I have understood
his argument
Yes.
precisely is that CDA rules say it is GM.
Yes,
So you'll have to be a GM.
he is a GM.
He says he's not a GM
Let him
by
show.
virtue.
Let
by
him show
virtue-
why he is not a GM.
By virtue of the rank and file or whatever it is.
Let him show.
his
He has to
post has
demonstrate
been renamed as, renomenclatured as a
that.
GM.
Correct, my lord. It is re-nomenclature. But the corresponding, there is no corresponding change in the CDA rules.
Not
No, no.
required.
Then does he still remain an AGM?
No, my lord. He is the GM.
He's the GM.
Not required. Can you allow me just one line? Sir, to
Wait,
comment?
we'll come back.
It is 780 pages.
We'll come back.
It is specifically mentioned.
So,
780 pages.
no,
is specifically
renomenclature. Supposing he was DGM earlier. Renomenclature, then he's become a GM.
GM.
So does it make him qualified
Yes, because he is the functional head of the department.
for let us say, for
Because
his promotions above?
The post above him will be director, my lord. No,
So he's-
now it is chief general manager. He is now the chief general manager. Then above him is the post of director. At that point in time, there was no chief general manager.
Is you referring to what?
780 page, Lordship.
I'm coming. I'll come to that, man.
Lordship,
I'll show that page.
sir,
I'm
it
coming
is
to that.
specifically mentioned that power delegated under delegation of authority whenever the designation are based upon designation, the power shall be exercised as per all designation. He should,
What is 7.8? What is the volume?
Honorable Supreme Court also,
No, what is the volume?
volume, Lordship.
Same volume, madam.
Volume 2, Lordship.
Same volume.
No, volume 3, Lordship. Volume
Volume
3,
three.
page 780.
780. 780.
Yes, Lordship. Last line, Lordship. And Lordship, that official order which he was authorized to act as a functional head never authorized him as a disciplinary authority. And that document cannot authorize him to exercise his power and authority as per new designation. It is specifically mentioned that as per regards to the delegate under delegation of authority, when our delegation are based upon designation, the power shall continue as per all designation. If this honorable court not allow me to mention each and every issue, then there will be, Lordship, with my folded hand, I mentioned that there will be grave miscarriage of justice. Because with due respect to the learned senior counsel, that he missed lots of communication. There will be at least give me a 1 to 2 hours, Lordship. I have seen that lots of counsel take at least 1.5 hours or 2 hours, Lordship. At least give me a 2 hours. I will only specifically mention this kind of issue, Lordship. Because transfer order was nullified. That is why I.
Wait, take your seat. What is the relevance of this letter? This
There is
communication?
a delegation of authority for doing various things, madam. But that order is that order is superseded by the page 556 order, madam. Because here 556 says specifically that Subrata Das will exercise the rights of functional heads in matters pertaining to disciplinary action as per CDA rules.
Then what is the date of that order?
Which order, madam?
Where he is designated?
12/3/2021. 10/7/2017 his lordship is reading, I think, 780.
10/7, yes.
And the subsequent order is 12/3/2021.
This is a CFD approval. They cannot overrule the CDA rule that was approved by board, Lordship. And management cannot delegate power. Management means MD&RL. They mention in the affidavit of opposition that MD&RL approve him as a disciplinary authority. But management means MD&RL.
Where does one find this delegation of authorities? Where is that? Is it under the CDA rules?
Not part of it. Delegation of authority for everything, madam. For floating tenders.
No, that's right. So is it a set of rules?
No, it is not a set of rules.
Then
it is a set of notification and circulars.
You produce that. Let us see what it says. Let us go to the root of the matter, since this is one of his grounds which he has been urging from day one, that this man is not competent.
Lordship, they mentioned that one pages they mentioned that management approve him as act as a disciplinary authority. One pages they mentioned that when he issued the memorandum of charges, he was in a designation of CGM. but document shows that he is a GM, and it is specifically mentioned.
Will you please take your seat? Allow us to interact with the
No,
council.
Lordship, I actually concerned about that. There will be.
Did we ever express that we will stop you from addressing the court? We are only saying that we want to hear him and we'll come back to you. Why can't you respect the request of the court? This 780, the last line. It appears that notwithstanding these delegations or these nomenclatures, there is something to do with the powers to be exercised as per the old designation. So it should be reflect to the delegation of authorities.
Let me have a try to produce the delegation of authority.
Let us see that.
Because my respectful submission is that 12.3 will supersede that, because 12.3 specifically empowers that person.
But 12.3 does not override these specifically.
But this is not an order. If your lordship sees,
no, this is departmental communication.
this is an internal communication.
By a senior general manager. What is the respondent number? R6.
R6.
And the records, the Committee of Functional Directors note of approval of this 12.3, or there is a 9/3/2021, the document is there.
By which order was he shown to be GM? Functional head?
556.
Yes. You check up and you let us know.
I'll do, madam. Even otherwise, madam, settled position, even then authority below the disciplinary authority can initiate. It is not dispute to that proposition of law. even otherwise, but the penalty order has to be by the disciplinary. I'll not trouble your lordships in many judgments. I have it, I'll produce that judgment.
Yes.
The issue is very simple, lordship. That memorandum of search required to be issued by disciplinary authority. That disciplinary authority either cause to be drawn up or drawn up also. Either disciplinary authority approve the search. There are lots of Honorable Supreme Court judgment where Honorable Supreme Court repeatedly emphasized that the memorandum of search to be to either approved by disciplinary authority or disciplinary authority himself required to be framed. But when respondent 6 issued the memorandum of search, he did not introduce himself as a disciplinary authority. Neither inquiry officer introduced himself as a disciplinary authority. They claim that if he was not a disciplinary authority when he issued the memorandum of searches, then why you did not approach to the Honorable Court?
Right.
I did not approach to the Honorable Court because they did not confirm that they were initiate the process for major penalty. For major penalty only disciplinary authority is required to issue a memorandum of searches. They initiate the process for voluntary abandon of company service. They mislead me. They even mention in the memorandum of searches that Numoligo refinery initiate the memorandum of searches. Numoligo, this cannot be an institutional decision, lordship. Numoligo refinery cannot issue a search frame against me, lordship.
All right. We'll continue on 12th.
Lordship, can you give
No,
us an
sorry,
early
19th.
date? Can you give us an early date because there
This
is
early date is only next week.
Can it be 21st because I have to.
Saturday, lordship.
Not on Saturday. Not on
Lordship,
Saturday.
kindly because this case is
No,
repeatedly adjourned.
19th we had agreed.
19th were the agreement. Subject, I'm just making a suggestion.
20.
Can it be on 21st?
Lordship, kindly give us an early date.
No, because we don't know whether we'll complete on 19th.
No, because if I have to get the delegation of authority, because it is around.
That you seek for.
No.
But meanwhile, whatever is there, we'll hear.
Yes.
The issue is, lordship, CTA rule approved by board, lordship. It is mentioned that where power is based upon designation, officer cannot act as per new designation, lordship. Then he cannot use the new designation, lordship.
All right. We'll examine that for further hearing on heard petitioner in person and Mr. Randeep Sharma, senior advocate, assisted by Ms. P. Fukan. Micus, appointed by the court, Mr. N. Deka, senior counsel, assisted by Mr. M. Gogoi, for NRL, Mr. H. K. Das, senior counsel, assisted by D. Mohanto, is for respondent 6.
4, 5, and 6.
4, 5, and 6. Further hearing released on 19th. It was the family. For the time being, it is. Very good. Yes. Yes. Thank you. Yes, is it correct? Calculation?
Calculation I have done, lordship.
Wait. One minute.
So lordship, we have to calculate it from 22nd of December 2021. If it is up to 21st December 2022, then it is 1,516 days total. Then we have to minus 422 days. That is the part when he was in Chhattisgarh or some other place. Then it will remain if we that is up to 10 to 2026. 10 to 26. That is when we have considered his representation and found it as devoid of any merit. If then it is absolutely 1095 days, and 365 days into 3 is also equal to 1095 days. And if we have to calculate it for the first order, that is of first transfer order,
No,
then
no, we are only saying
lordship.
that this counting will have to be done from which date?
From 22/12/2021, when I came into this Assam Meghalaya cluster, to the date of the transfer order, 22/12/2025. The impugn order was issued on 22/12/2025.
22/12.
2012.
Yes.
So from that period, it is 1461 days. 1461 days. 1461 days
From 22.
22/12/2021
Till the impugn
to the
transfer
impugn
order.
transfer order. It's 1461 days. So number of days, according to my calculation, I had spent 559 days. But since they are only calculating the periods
90
which are
plus.
more than 90 days, then it will come down, your lordship.
423 days.
423 days. Now, even if we take that, your lordship, then the required number of days would come to 1038, which is less than the number of days 1095.
The another aspect is their lordship. Then we considered his representation. He had submitted it, and as per that, the next order is 10/2/2026. If we will calculate, then the difference will be less, only 6 days or 7 days.
No, which order?
Then that page number 91.
I had submitted a representation. That representation was
We have
rejected.
stated that the requests have been rejected because of administrative. In that, if we will consider that date, then it will be only difference of 7 days till completion of absolutely
Even then
3
it is
years.
not clear.
And in the first transfer order, lordship, that first impugn order, that 22/12, it is very specifically mentioned that although it is an order of 22/12/25, but the summer chain transfer will be effected only from 1st of April 2026. So in that way,
So you are saying that instead of this when is the impugned order?
22/12/2025.
22/12. The date should be counted is 1st of April.
1st of April. Now another 1.5 years, but that is not only for this. This is a general one, so we will not go to that. But it will come into effect from 1st of April.
No, 1st of April is the date when they are to march out. But the order of transfer will.
But that summer chain transfer, they first have to, because they have the opportunity to even submit their representation also, which he had also done. Because we have.
So therefore, it is rejected. The reasons are not forthcoming why it is rejected.
No, reason is administrative reason. Once his representation, lordship may kindly go through his representation. Mostly his representation is on the that he had some medical issues. Representation, lordship, page number 88.
You consider it again in this aspect.
This person has given opportunity to stay for group center because of his medical condition, which he has operated.
Right, but we are going by the interpretation by your own transfer rules,
lordship,
where the tenure is defined and what is how it is to be calculated. So
this representation was already considered, lordship. Then we passed the order 10/2.
So now, assuming his submissions are to be accepted,
yes, lordship,
he becomes eligible for transfer in the next round.
Next.
It's a very technical issue, lordship. It's a armed forces, lordship, and on such a technical, so small date of if 10/2, then
how is it small? There are more than 3 instances of 90 plus days.
No, that we have minus already. If we calculate that, then it is much more.
That's right. No, then you'll have to give him that benefit under this definition of tenure.
Yes, lordship. But then also it's a very small margin of only 6 or 7 days. For
So
that,
how is it 6 or 7 days?
yes, lordship, 10/2, if we
So
calculate,
they are
is 10/2.
calculating from 10/2.
10/2.
From the date of
When we rejected
cancellation,
his.
date of rejection of
And
the.
then also, if we calculate it from the first date, then it is 57 days, not even 2 months. Someone has to stay in that area for 1 day, but he had already given benefit of staying in headquarters also for medical ground. He is.
Whatever it may be, you consider it, you have to give him that benefit. You see, your tenure definition says that if he's on attachment temporary duty for more than 90 days, that benefit you have to give him. Now, this transfer is summer chain transfer is on completion of how many years?
3 years.
3 years. So if he has not completed 3 years by that calculation, he is entitled to the benefit to be considered.
That I will not submit that lordship for 2 months. Let us take it just for 2 months he is short. But someone has to stay for administrative reason for some other places. If for another 10 months because of that also have to see because it has to be lordship.
You are saying that
We-
he has been transferred.
Yes, lordship. And more so when it is come to effect only from 1st of
No,
April.
but it is not transferred on a man-to-man basis, is it?
Not
It is
man
not-
to
it
man
is not
basis.
It is not a case like the transfers which are issued in, say, administrative departments, where one person is transferred, the other person is posted somewhere else. It's not a case like
But
that.
he is in the home state for so many times. Some other persons are already in the other different state. May not be man to man, but as a
No, but if your summer transfer will be on a cutoff date of 3 years. But to calculate these 3 years, you have to give the benefit of 90 plus days. He has more than 4 sets of 90 plus days. Those benefit he is entitled to by your own rules. So if that benefit is given to him, he does not complete 3 years. Rest is up to the department. You decide when he should be transferred again and wherever. It's not a case that his case after completion of 3 years will never be
but
considered.
lordship that may kindly be reflected that on 1st of April or on when we had that criteria of transfer. We have the criteria to transfer him, but on the date of that impugn order he may not have, but that will come into effect from 1st of April.
But then this will not be a summer chain transfer.
It will not be, then it will not be a summer chain transfer.
But this is a summer chain transfer. It is in the transfer order itself that it will come into effect from
If they transfer.
lordship, that clause.
If you now transfer him with effect from 1st of April,
Lordship.
you may transfer him on any other ground. That's a different issue. But will it be a summer change transfer? It will not be a summer change transfer because summer chain transfers took place in December.
The December, but all person, no one was transferred. That is only coming
No, but the order was passed,
Lordship.
effective to be given effect on 1st of April.
1st of April.
Now 15th of May, isn't it?
15th of May, not because of any stay order, but because that election purpose.
That's right.
That by that order, lordship, not only the petitioner, many others, but all are enjoying the same benefit up to 15th of March. That benefit is a general benefit up to 15th of March. Otherwise, also they have to proceed on 1st of April only. So that is a general principle, general condition. That is the summer chain transfer.
But we'll give the liberty to the department to pass appropriate order. Heard Mr. K.P. Pathak, learned counsel for petitioner, Ms. B. Sharma, learned CDC for the respondent. The petitioner is presently serving as
Head constable.
head constable,
Constable.
constable GD,
Constable GD.
constable GD.
Constable.
In the Central Reserve Police Force. Petitioner is presently posted in Assam.
Gauhati.
Group
Guwahati.
Center, Gauhati.
Center Gauhati. By the order, where is the impugned order?
So page number 86.
By the impugned order, dated 22/12/2025, the petitioner along with other similarly situated persons were transferred to various units allocated to them as reflected in this transfer order. Stop. The petitioner, insofar as the petitioner was concerned, he was transferred from Group Center Gauhati
127 battalion.
to 127 Battalion, which is located in
Orissa.
No, lordship, West Bengal.
West Bengal.
West Bengal. My affidavit said it's West Bengal.
Name of the petitioner is reflected in serial number 6 of the impugned order. So, according to the petitioner, he suffered from medical ailments and had represented before the authorities to reconsider his transfer to West Bengal to the said battalion, but these representations stood rejected. Stop. Being agreed, the petitioner is before this court. Para. The respondents have contested the case of the petitioner by filing their affidavit. So, in their affidavit, there is the petitioners, the government's made. The respondents have contested the case, stating that the normal tenure of transfer is 3 years, and the petitioner having stayed in Assam for more than 3 years,
More than 4 years.
more than 4 years, he is entitled to be transferred out in the summer chain transfer orders which are effected by the authorities concerned. Stop. There is no infirmity in the order. Stop. In any event of the matter, the transfer orders were initially, in the transfer order itself, it was stated that the orders will be given effect from 1st of April 2026. Stop. Subsequently, however, in view of the ensuing assembly elections which were conducted in the state of Assam, the transfer orders were put on hold till 15th of May. Stop. As such, since the elections are over, and there is the transfer orders are still on hold till 15th of May, and there is no specific instructions or orders issued received from the headquarters as to whether there will be further extension of the marching orders, or the transferred officers be required to join their places of posting after 15th of May. The learned counsel for the petitioner, the petitioner filed a rejoinder affidavit where they have brought out the particulars of the places of posting of the writ petitioner during his career. Stop. It is submitted that although the petitioner's unit was posted here, he was transferred. He was, what do you call it, transferred or attached?
Attached.
He was attached to different units in Chhattisgarh, and for more than 90 days on several occasions. So, where are the learned counsel for the petitioner referring to the what rules?
This is standing order 4 of 2020.
Standing orders 4 of
Actually, amended standing order.
amended standing order of
114.
4 of
Clause
2022,
3D.
dated 27th of
No, 7th of
September.
October.
There is a small, otherwise the substantive provision remains the same. Your lordship turns to page number 140. The word cluster has now been inserted. 114 on their affidavit in opposition. The
That
word cluster has now been
3D
inserted.
definition.
Earlier,
Amended read as
the concept of cluster was brought.
3N.
3D. First one. Amended read as 7th October 25. Standing order 4 of 20.
So the standing order dated 4th of 4/22, dated 27th of
No, 7.
2022, amended as up to date, submits that the tenure is defined as a period of continuous posting in a particular station, area, region, or cluster, as cluster within bracket or DO, as amended subsequently on 7 October 2025. Stop. However, if any official is on attachment or temporary duty from a specific area for more than 90 days, the period of such attachment or temporary duty will be counted towards the tenure of that specific area where he is attached on temporary or where he is attached or on temporary duty. So, the counsel for the petitioner therefore submits that since the petitioner was on attachment for more than 90 days for the periods 8th of May 2022 to 6th of August 2022, 12th April 2023 to 11th July 2023, 8th of October 2023 to 6th January 2024, and 31st of January 24 to 28th of June 2024, totaling to a total of 423 days, these benefits ought to be granted to the writ petitioner while calculating the period of 3 years for the summer chain transfers. Stop. It is submitted that if the benefit of the period served under attachment by the petitioner for a period of more than 90 days is taken into account, then in terms of the procedure, in terms of the standing order, the petitioner did not complete the period of 90 days, period of 3 years, in order to make him eligible for summer chain transfers. Stop. Error. Learned counsel for the parties have been heard. The pleadings available on record have been carefully perused. The definition of transfer is as defined under the Standing Order 04 of 2022. Reads as under clause 3D. Whereas summer chain transfer is prescribed under clause 5, capital A, which reads as under summer chain transfer, page 77. 77, 78. So, from the perusal of the standing orders, it is apparent that ordinarily upon completion of a period of 3 years, the incumbents are entitled to be transferred out to various other places across the country. However, in order to, while determining the period of 3 years, the reference to the term tenure as prescribed under the standing order has to be taken into account. Stop. In terms of clause 3D, the tenure defines a continuous posting in a particular area. However, the period, if the period served by a personnel on attachment or temporary duty from a specific area for more than 90 days, then the period of such attachment or temporary duty will be counted towards the tenure of that specific area where he is attached or temporary duty. Stop. Conjoint reading of the provisions reflect that although the battalion to which the petitioner is attached has been posted in Assam, however, the petitioner was intermittently attached on temporary duty outside the state, more particularly the state of Chhattisgarh, on several dates for a period of more than 90 days. Stop. If the description of tenure as per clause 3D is to be taken into account, then the petitioner has to be given the benefit of the period of service rendered on temporary duty or the attachment for more than 90 days. Stop. from the chart, which is enclosed to the additional affidavit, the periods where the petitioner had spent more than 90 days are reflected. If the total number of days are to be counted for which the petitioner rendered his temporary service outside the state of Assam beyond the period of 90 days, then the total number of days he had served on attachment or temporary duty comes to 423 days. Stop. The stop. If that be so, then the 423 days will have to be deducted from the total number of days the petitioner has served in the state of Assam for a period of 3 years. Stop. The total number of days ordinarily required to be counted for service rendered in the state of Assam for 3 years would be
1095.
1095. And after giving the benefit of 423 days, the number of days spent by the petitioner in the state of Assam would be
1038.
1038. Stop. Therefore, from the chart which is enclosed to the writ petition, to the additional affidavit, the position on facts is not disputed by the learned CGC. Stop.
Only one thing, Lordship, that if it is counted from 1st of April, that one line maybe. My submission is that if it will be counted from 1st of April, then
The learned CGC, however, submits that since that notwithstanding that the orders of transfers were issued on 22/12, is it?
12.
22,
12.
22/12/2026,
5.
25, the effective order ought to be counted only from 1st of April. As the marching orders, as reflected in the impugn transfer order, are to be on 1st of April. And presently, the marching orders are suspended till 15th of May. So, therefore, the benefit that may accrue to the petitioner for the number of days which the petitioner claims he has spent beyond 90 days will have to be counted from 1st of April instead of 22nd of December 2026. Stop. If that be so, 25. If that be so, then the petitioner will be entitled to a benefit of only 15 days.
No. In that case, it is over.
If that be so, then the petitioner cannot claim any further benefit.
Eligible for transfer in that.
And he'd be eligible for transfer. Technically, she's right.
Now,
You're still in Assam for past 4 months.
Yes.
I may be eligible for then I'll be eligible for a summer chain transfer on the next round. When this order was passed, then I had not completed the required number of days. Yes.
Well, however, the submission of the learned CGC, in the opinion of the court, cannot be accepted as the order of transfer was issued on 22nd of December 2025. Notwithstanding that the marching orders would be given effect to only from 1st of April 2026. Stop. In any view of the matter, even if the submissions of the learned CGC are to be considered and sustained, and the benefit sought by the petitioner of 423 days, even after being considered, would be over by 1st of April, extended to 15th of May 2026, and that the petitioner would be eligible for transfer, then separate summer chain order transfer orders will have to be issued. Because on the date when the summer chain transfer order was issued on so and so date, petitioner did not complete his tenure of 3 years. If the benefit of attachment or temporary duty for more than 90 days is to be granted the petitioner, and which benefit will have to be granted in view of the specific definition in the tenure is specifically defined under clause 3D of the standing order, so and so. In that view of the matter, the writ petition stands allowed. The impugned order dated so and so in respect of the writ petitioner stands interfered with. Stop. It is, however, made clear that the department would be at liberty to pass any effective orders if the petitioner is otherwise found to be eligible for transfer under the so and so standing orders disposed. If interim orders, if any, stands merged.
My lord, perhaps the rejection order would perhaps also have to be set aside. The order page number 91.
Rejection order, in view of the order passed so and so, the rejection order dated so and so will have no effect.
Well, 10 to 15.
Yes.
It's a long day. Can it be other day? Not, we had a long heavy. Yeah.
Day after tomorrow, no problem. No, it is only on the day when the
Yes,
promotions were effected,
Yes.
the petitioners.
yes, I have the copy.
Let us see.
Out of copy. No mobile number there. I agree. I don't know. In the earlier, when the service rule was not amended, when there also was there in the second page also. As per the existing 100-point reservation for promotion, there were existing vacancies in the following points. That is 31, 32. That is they are showing that, and one post from unreserved penny is kept vacant for PWD candidates. As per WM number so and so dated, as there is no officers in that category who completed qualifying services. One post for SC and one for STH is kept vacant.
So 3 posts.
Kept vacant. Sorry, because SCS. One is personal disability. One is PWD means personal disability.
How many posts were there?
As per this roster, that is 1, 5, 6, 7, 8. There is a unreserved post 1, 2, 3, 4, 5. One is
No. Where do you find it?
second page also.
Second page. There are 7 persons.
Yes, sir.
So there are unreserved 6. 6.
Yes, Lordship.
1 STP,
Yes,
1 PWD,
yes, Lordship.
1 SC,
Yes,
and 1 STH.
Lordship.
So 7 plus 3, 10 posts.
Lordship.
So according to you, there are more than 10 posts.
My lord, the anticipated vacancies, my lord, they did not consider. Rule says that, my lord,
Anticipated vacancy arising in the year of 24.
my lord. Immediately after the promotion order was issued, the director communicated the, my lord, commissioner that there were 6 more posts lying vacant.
All right, these 6 more, they will have a separate process to fill it up.
My lord, second DPC was held.
Hmm.
The result of the second DPC was not declared. The DPC, my lord, in the second DPC, the DPC was.
What is your prayer now?
My
You are
prayer
not challenging their appointment.
I'm not challenging their appointment.
Yes.
My case is that, my lord, as the posts were lying vacant, as we are, most of us are working as in charge in their post, our cases should be considered, my lord, with retrospective effect. If not, my lord, in the first DPC, the second
It is
DPC,
a decision of the department to fill it up, when they want to fill up.
my lord, the second DPC was held. Second DPC, my lord, did not, my lord, publish the result of the DPC, and in the meantime, my lord, they recommend for, my lord, amendment of the rule. The DPC, my lord, they recommended the amendment of the rule. Already they have implemented the rule in one hand. In the second DPC, they are of the opinion that, my lord, the persons, the petitioners before lordship are not qualified.
This is what, first DPC, second DPC?
This was prior to amendment. Lordship.
This is prior to amendment.
Prior.
So where is the recommendation for amendment? Here?
Another one.
This is subsequent. That is subsequent.
My lord. 2025, my lord, there was another DPC.
How many persons are there?
Because
The second DPC, your cases were not considered.
My lord, considered, but they did not publish
Or
the
did
result.
not publish the results.
it's in the record.
Now, what is the right of an employee?
The posts are lying vacant. They are working on as in charge.
Right to be considered,
My lord. My lord.
but they will consider you at the appropriate time. But
As the
is it a
DPC
case that
was
because your
held,
cases were considered by the DPC and the results not published, your valuable right has been violated? Is that the argument you want to make?
my lord, that the Chief Secretary of the department says, Chief Secretary of the Government of Assam, my lord, he, my lord, asked all the commissioners to fill up the vacant post immediately, as and when it arises. The posts are lying vacant. The persons are working on discharge basis. DPC was held.
What is the status of the rules?
Because of the rules.
Amended.
Amended. Lordship.
That
Now
have
amended.
Already amended.
Draft rule has been published, my lord. They have not, my lord, it has not been notified.
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 Notified, right? Given the affidavit also.
In the affidavit.
Well, it's been notified.
Page 90 of the comment. WPC 2421.
This amended.
Where is it?
Page 90.
90.
Page 90 of WPC 2421.
These are amended rules.
My lord.
Then why did you say it is only draft stage?
The petition is not next one ahead of the.
So now the rules are there, so the department will have to follow the rules.
If the second DPC, the second DPC, the DPC recommended for amendment.
Maybe,
How the DPC
maybe
can
it is
recommend?
irrelevant, but assuming it is irrelevant, now that the rules have been amended and published,
My lord.
the rules will follow.
But at the time of considering, my lord, at the time of consideration of the DPC, my lord, this rule was not there.
May not be. So there is that earlier law, it has undergone a lot of change. Department has decided that the rule amendment is necessary. They've amended.
My lord, after filing the petitions, my lord, they have amended the rule.
No, but you said the recommendation was given by the DPC, so there was some decision that the rules should be amended.
My lord, they say that, my lord, the experience in the cadre of, my lord, subdivisional.
Means you give us any authority that vacancies prior to amendment, later judgments, not Ramulu, after that. Agarwal,
My lord.
Dinesh
Deepak
Agarwal,
Agarwal.
Deepak Agarwal.
My lord.
Deepak Agarwal is very clear.
Deepak Agarwal is in my favor, my lord.
How is it in your favor?
But at the time of consideration, my lord, the earlier rule was there.
You show us
When the
judgment.
second DPC was held,
Give us a copy.
paragraph 26.
You read the next line.
My lord. There is no rule of universal or absolute application that vacancies are to be filled invariably by the law existing on the date when the vacancy arises. I do not say that, my lord, it should be considered on the date when the vacancy arises. It should be considered on the date when the consideration was made by the DPC. Consideration was made in the year 2025, and the amendment rule was not there at that point of time. The requirement of filling up the old vacancies under the old rules is interlinked with the candidate having acquired the right to be considered for promotion. The right to be considered for promotion accrues on the date of consideration of the eligible candidates. Unless, of course, the applicable rule, as in YV Rangaiya case, lays down any particular time frame which the selection process is to be completed. In the present case, consideration for promotion took place after the amendment came into operation. Thus, it cannot be accepted that any accrued or vested right of the applicants has been taken away by the amendment. In my case, consideration was made prior to the amendment. So, my lord, I have a vested right on the date of consideration. I was eligible. My case should be considered by holding a review DPC, my lord.
Yes.
Okay, yes, my stand is very that after at that point only they were not under the zone of consideration prior to amendment. Here also after the rules are amended, now there is no scope for taking, and they have not challenged the rule also. They have not challenged the new rule. Now we cannot go for this also.
Where is the second thing? Memo, the second DPC.
Second DPC, it is in the report, I think. So I've given on the last date. Fine.
Second DPC.
Fine. Second DPC was held in the month of April.
Where is the minutes? What is the date of the minutes?
Second DPC, my lord, 9/4/2025. 9/4/2025.
It was not considered. Your cases for promotion were not considered by the DPC. They noticed some disparity under the rules. And they all agreed that this disparity has to be removed.
But same rule DPC, the same DPC, my lord, by applying the same rule, they have, my lord, promoted in the earlier DPC, our best mates has been promoted.
Maybe, but then this issue was not raised. What, you see, your argument is that your cases were considered for promotion. Therefore, your right accrues. And therefore, the amendment is not going to affect you. Your cases will have to be considered with the pre-amended rules. So the accrual is to be determined from when? From the date of the DPC, taking up your cases and deciding that yes, you satisfy the criteria, you will have to be promoted, etc. So nothing has been discussed here. They have rather said that there is a discrepancy in the rules with regard to the total years of service. And all the members agreed, and then therefore it was recommended that this rule should be.
Whether by after applying the same rule, after applying the same rule in case of our best mates, whether that can be done for selectively, deny us.
And you are alleging malice against these officers, that they have deliberately decided not to apply and therefore resulted in this particular. There has to be malice alleged. Otherwise, if you say that yes, your cases were considered.
Our cases were placed before the DPC, my lord, for consideration.
Consideration.
Vacancies were there. Vacancies were there. After filing the writ petitions, my lord, we filed a writ petition on, my lord, 30/4/2025. On 30/4/2025, filed a writ petition. And my lord, they have amended the rule, my lord, on February 2026.
There is no quarrel that the rules have been amended. If you are agreeing, you can go and challenge the rules before an appropriate forum. But only question is whether you have a right which is accrued to be considered.
Kindly take up, my lord, the 2022 4 SCC, my lord, 363. Punjab State Cooperative Agriculture and Development.
Yes.
My lord. Paragraph 49, my lord. The exposition of the legal principles called out is that an amendment having retrospective operation which has the effect of taking away the benefit already available to the employees under the existing rules indeed would divest the employee from his vested or accrued rights, and that being so, it would be held to be violative of rights granted under Article 14 and 16 of the Constitution.
This is an amendment with retrospective effect. Here, this is not an amendment with retrospective.
Here, though the amendment has not been given the retrospective effect, but our vested right has been taken away because of this amendment.
That is what we are saying. What is a vested right?
On the date of
the right to consideration for promotion is a right.
Yes, ma'am.
Right to, there is no concept of right to be promoted.
On the date of
there is a right to be identified, the right for consideration.
Yes,
you have to be considered.
Yes.
So, they presented your case, the consideration was undertaken before the DPC. DPC noticed some anomaly in the rules.
Whether that can be done by the DPC.
You show us from any authority that it cannot be done, that one set of your colleagues were already given the benefit, the other set has not been given benefit, then it leads to malice. If not in fact, then at least in law. But that you'll have to urge somewhere. That they deliberately ensured that these, for whatever reasons or grounds you may urge, but in order to take the benefit of Deepak Agarwal, that your rights had accrued, you'll have to show that what is the point where your rights accrue.
Our cases were considered even in the first DPC also. Even in the first DPC also, our cases were not considered. We were not found to be fit. Because the posts were 10 posts were they have considered 10 posts instead of 17 posts. Rule says that they have to consider the anticipated vacancies also. The vacancies which are going to occur within the year, they have to consider those vacancies also.
See, this argument can be countered. Say that if they had considered these anticipated vacancies, then somebody who may have become eligible in the next year otherwise would have lost their chances. So therefore, if it is not considered with the earlier DPC and is subsequently considered by a separate DPC, then any other person who may have become eligible will also have the opportunity to participate.
Criteria for promotion in this case, is seniority come merit, not merit come seniority. Seniority come merit, and the gradation list is there. The gradation list.
You have not been able to convince us that any vested right or accrued right was taken away.
This particular issue, mostly pick up on Thursday, on
Thursday, we have a lot of matters fixed.
Only for a small issue, whether the DPC can recommend the authority for amendment of the rule.
That's part of matter agreements.
At 2 p.m.
Why don't we take it up on 21st? 21st? 21st. Matter to be listed again for hearing on 21st. Counsel for the petitioner like to address the court by referring to authorities in support of his contentions that the vested / accrued rights of the petitioner towards promotion to the next higher post were taken away by the authorities by not considering the cases of the petitioner prior to the amendment of the service rules.